May 30. So do you consider back to mention item 30 or 30?
30.
Can it be after 3 weeks? I need to file the reply or
The request of learned counsel. 20.
much obliged, your
May I please? Item number 23, my lord. But it may be taken up after 2 weeks, my lord. I have taken the concept of the others also.
The request of learned counsel.
2 weeks.
2 weeks.
Yeah, please, your lordship. My lord, I beg to mention item number 60, my lord. My lord, today I'm going to file the affidavit in the service affidavit, my lord. Let it, my lord, after 1 week or 2 weeks, my lord.
Item 60 be taken up after 2 weeks
My lord.
as the council submits the new type 5 affidavit for that.
My lord. Obliged, my lord. Yes.
My lordship, I beg to mention for listing one family pension matter. Next week, my lord, any date.
Wait, please, my
Obliged.
lord. Like to mention item number 5 of today's list.
Hmm.
I've taken the consent of the other side. Let it be listed after 2 weeks.
Item 5 listed after 2 weeks at the request of learned counsel.
Obliged.
May I please? So I beg to mention for listing of a lordship. Matter relates to suspension law. I need to next week.
First of May.
Lordship, on behalf of Mr. N. Borua, I beg to mention item number 8. Lordship, he is hospitalized yesterday and he is diagnosed with typhoid and pneumonia. So the matter.
Listed after 4 weeks. I think the council.
Lordship, a date may be fixed.
After 4 weeks, you mentioned fix a date.
Yes, Lordship.
Lordship, with the consent from other side, I beg to mention item 33, Lordship. Finally, the matter may be taken up after 2 weeks.
33
Yes, Lord.
after
2 weeks?
you are mentioning on behalf of the petitioner.
Yes, Lord.
Item 33 is request of learned counsel.
But
Infrastructure.
in not in function, my lord, my client is in the hospital, my lord. That's why you couldn't take the instruction.
No, but that,
But
that
one thing, my lord,
last time,
I'll file an affidavit in a reply, my lord, to the affidavit of opposition filed by them, my lord. Let it be taken up next week, my lord.
you are posted in Guwahati,
What you want?
then whatever,
I'm attached. I'm attached.
then whatever medical procedure
Yes.
you have undertaken,
Yes.
that has had positive result.
Yes.
Now what do you want?
Yes. She has applied for leave also, my lord. She was under leave on medical ground, my lord.
Right. What more is required? Yes, what do you take up?
Actually, she has not reported on duty since
She's not supposed to be on leave,
Medical leave.
Yes, my lord.
medical leave.
And now, my lord, the good news is that she is now conceived, my lord.
That's right. So therefore you are entitled to all the leave that is available to you under the provision of.
Yes. Or I'll file an affidavit, matter bringing this on record.
All right. Yes, any objection to that?
No.
Mr. J. Roy, let us begin now. After 3 weeks.
Obliged. Affidavit. Okay. But
Lordship, the difficulty here is that, your lordship, the petitioner, she had retired from Mongoldoy town HS school, your lordship, and that is in Dorong. Inspector of Schools Dorong has to be implemented, your lordship.
Oh, the Department of Education
Lordship.
Secretary or Director is implemented.
Lordship.
So can the director not find out from the concerned officer what is the status? Why this
Lordship.
technical objections are we?
Lordship. Lordship, because the inspector of schools, they will have to forward the proposal, your lordship.
Right, so their
Lordship.
information, why is it necessary to implead
Lordship.
and then
Because,
ask, is the
Lordship,
director so busy that
Lordship.
they can't find out that
Lordship.
information?
No, lordship. Lordship, after a week, your lordship, I'll get the instruction.
Madam, these grounds for adjournment are not.
Lordship, instructions in that way is it's awaited, your lordship. Because the,
Evaded in what sense? Your objection is that the inspector is not a part. When you do not know what is the status, if
lordship,
there is some decision to be taken,
lordship,
respect of the inspector. Very carry.
lordship, because here, your lordship, for a certain period, she was in Sivsagar district and then she was transferred and then
again you say
posted.
Sibsagar inspector is also necessary part.
Lordship, no, they have made Sivsagar IS a party, your lordship.
Then?
Then she was transferred and posted in Dorong, your lordship.
So you get the information why they have not
Lordship.
finalized the papers. Mentioned that
Lordship.
authorities are not expected to be told.
And the pension proposal is directly, lordship, proposal is submitted by the IS to the pension department.
Who will submit?
The IS, Inspector of Schools,
Which IS?
Inspector of Dorong, your lordship, because he has retired from Dorong. Here, Sivsagar has been made a party, your lordship. Inspector of Schools, Sivsagar.
All right, heard. Submitted by the judge, sending out that if the prisoner has retired from service from Mohondo town, high secondary in the district of Dorong. The papers are required to send directly to the pension department by the inspector.
Dorong.
However, the inspector of Dorong not create party for under some circumstances, the education department, the study council is not posted. In view of the subject, the inspector of Dorong, the area of the party is for number 8. The report. It includes
Lordship.
the newly created important rate of the study council appears sector the waiver of the party within a period of this week. Meanwhile, the petitioner will file amended motorcycle to party. The respondent number 8 will face to the court the reasons as to why the pension paper relating to the petition has been forwarded to the concerned department. With the instructions given to the court, these three matter be taken on 20 May 0.
Lordship.
After estimating for the
Obliged, your lordship.
Lordship, I was recommended as tutor against supernumerary post, my lordship. Till date, my salary has not been released, my
My lord, difficulty is that respondent number 5 is claiming her appointment. My lord, that appointment is her. So my lord may direct the Secretary School Education to verify and pass necessary order.
Yes, my lord.
what
That
is
will
the-
do.
what is
This instruction is there in this regard, my lord.
what does it say?
Director says that all records are with the Secretary to the Government of Assam. So
Okay, heard learned counsel to be party. Right. But you were appointed as for tutor.
tutor,
Yes,
my
my
lord.
lord.
He was
Page 55.
as per instruction he was irregular teacher and later appointed as tutor. Accommodated as tutor.
Petitioner was appointed as a tutor.
Accommodated, my lord.
Accommodated, my lord.
Accommodated as a where?
My lordship, in Dhanipur, LP school, my lordship. Page 55 is the appointment letter, my lord.
What is the meaning of accommodated?
My lordship,
She was irregular teacher, madam. Illegal teacher. Yes, madam.
Accommodated. in
Ravidas
Para, Hailakot. I ordered it in 23rd of September.
my original school was Dhanipur ME school, my lordship.
It's up with that. Person, her booked it, tutor, went to- by creating a particular book. As per the policy taken by the government. The petitioner continued letter of then what happened?
My lordship, till date, I have not received my salary.
When did you join?
My lordship, I joined on joined at 24/9/2022, my lord.
Where is that joining letter?
My lordship, page
As per the joining letter, joining letter. Salary support. He agreed with paying for the order. Era, your location, the examiner, sending out the when the element before the high, the office of the secretary,
Yes, ma'am.
school education, as per
The respondent number 5 is claiming that that appointment was her. That some typical error
respondent 5 is
claiming. Jahana Begum.
very
Lost.
respondent 9.
Respondent. Respondent nine.
she didn't join the post, my lordship.
It submitted that there is some that name the appointment. If the names of the teacher, respect of the date appointment between the petitioner and the respondent of 9. Petitioner is Sahanara Begum of 4. He did about 47 years of paid Handi up to Chile for wife of Mina, a resident of Dada Parkwa. So completed years Dada married. Respondent 9 is Sahanara Begum. Not Hani Doctor State on part of his life. There are things that only relevant dating the are dated the office. Respondent directed to it and after exam of the court made past the picking order. So these are ordered and past copy their the respondent 9 or any other interested party should be given notice heard before the picking order. For the purposes of carrying out the directive, the respondent of the consider present restriction the by the entire exercise of 30 days from date of Let us make
Highly
it
obliged.
60 days.
Yes, my lord.
60 days for the date.
Highly obliged.
My lord, kindly pass over the matter for the time being. My senior is in the court.
They have filed the
Another item.
affidavit, they have admitted it, and the payment structure is also given, my lord.
Dispose it of.
Lordship. Only thing is that my lordship comes to the affidavit, para 6, every structure has been given. Only thing is that 7 lakh rupees is the casualty amount. They should have released it immediately. And if not, there are penal provision there, they have to give interest. I am not asking for any interest, no, that amount be released immediately, 7 lakh rupees. I am not asking for any interest, my lord.
Let it up.
Lord.
Thank you.
Thank you.
Pass over.
Wait, with the lordship, my lord, last order dated 5/4/2024. And the attorney took 2 weeks time to take instructions.
Very simple, Catonia.
Yeah,
Here, my lord, I have received instruction that some documents are required. My lord, director has written to the DEO to resubmit the proposal, my lord. So, my lord, may I issue notice?
I have no objection regarding, but the only thing is that, my lord, now after filing of the case, the director has sought for certain documents. Earlier, my lord,
So what is the stage now? Your papers have been sent by the inspector.
yes, my lord, I filed a representation before the inspector and before the district elementary education officer also. And that now he says that some more documents is required from the DO. That's why this is sought for some more.
What document? What
My lord,
document you show it to him, why are you showing to us?
my
Show it to him,
oh, my
what documents are there, what is required or not. Have a look.
Yes, sir. But this is my lord, the internal documents. One is a non-royal certificate not duly countersigned by the TO, Treasury Officer. Finance Department prescribed format is not submitted along with the area salary claim. That is proposal, my lord, that they will have to file the proposal, my proposal. The pay is running a ban, so and so is shown as 9,120, but why this same is this decrease at 8,450 in the month of July 2000. So clarification required in this regard.
These information are necessary
from DEO.
Yes, DO. This is internal reform.
Elementary, my lord.
Elementary.
Order.
GPF paisa niki GPF to GPF pala
GPF to number
paisa department to education department to education na
areas. Price report. What
no here my lord, my little submission is there, your lordship due permission.
Yes.
Because this matter are relating to education department, we do not grant pension by accountant general. No, just let me submit. Because this pension is a director pension division. We pay only GPF, my lord. Now my lord has a customer told me that he or she has got already GPF.
Well, this is not regarding my lord pensionary benefits. This is for area salary.
No,
Because
that is why
I know-
No,
we have
why-
made
that is
no,
why
Why accountant generally?
Is required
Why?
that
Because my GPF account was initially wrongly allotted. That's why this area salary was not paid. That
if so,
hereafter, this my
then I'll
GPF
be-
account has been.
if so, I'll be available. Because but GPF has been, I
We
don't
have no
know.
objection again.
GPF has
Otherwise,
received.
a very hard pressed counsel, so don't unnecessarily array him unless you have claim. Yes, Mr. Borua, okay.
Now I'll be there or I'll be out.
He wants you to be there
Yeah, my lord, okay. It's my pleasure now.
unless he says you are not required.
Yes, that's correct, my lord.
His presence is not required, my lord.
Then not required. Okay, my lord.
That's the GPF.
No, my lord. It is area salary because of wrong allotment of the GPF.
Now GPF is
Yes,
clear or
yes.
not?
Already a GPF number is allotted.
GPF. Accountant general not be arrayed.
My
Same is the hope of array of funds. Sectioner will file and both sides. Registry will make necessary endorsements after the by releasing the name of the account. Registry will also not
highly obliged.
But it date may be fixed, my lord. after
20.
Higher.
Next is your lordship. In the last occasion, lordship, in this case, instruction was called for lordship petition was under subsection change 17/4/2023 lordship.
Yes, what is that?
Our case is that there is no review of extension for the suspension of.
Why don't you file appeals for the department? Department will look into all these aspects. Will direct them to hear all the appeals in terms of the law laid down by the court, by the office memorandum, which is earlier.
Lordship, the thing is that your lordship may not, may we read our own letter which we sent, because it is given in a question answer format. We asked 3 questions, they answered the 3 questions. Your lordship may not be able to understand without our letter, your lordship.
Departmental proceeding has been initiated.
Lordship.
Subsistence allowance paid.
This is a
And
Lastly, your lordship, we asked whether review regarding suspension of the petitioner has been made as per law. That question, your lordship, no, and then they said the following other words. No, as the petitioner.
So this will be examined by the appellate authority.
Absolutely.
Who is the appellate authority? There is a provision for appeal after the.
Lordship, here
Direct
since
them to treat this petition as an appeal.
appeals file an appeal.
Till date, lordship, so disciplinary proceeding also not completed, lordship, which is pending.
You are not completing disciplinary proceedings here. Hard. Where is the suspension order?
Case 29 in Exar 5, lordship.
I ordered it 17th April. The petitioner was arrested in ACP case number 24/2023 under section 7 of the Act 88. And such suspension 6 that is the date of suspension. No review as mandated in law was undertaken. And they did as it kept up earlier. The respondents were directed Department. To the board. But submitted for that. Identify number. Of however, conducted as per reviewing conduct. The learn from calculated hard. Really seen that based on the basic in order to of the assumption we learned how to result report that the law laid down by the FX code ahead of the judgment of the has not been adhered and as a consequence thereof. The restriction was not due before expiry of 90 days. Before expiry 90 days from date. Under such circumstances, that it be allowed that the due order of inspection prepared that board has the provision for the fee, maybe that when there is no fee, that it or not entertain unless it is an paid. Having heard an account that board does have provision for fee. Government may appeal against the order or made or is deemed to have been immediate. The current has not as why being amended take it type of every and there is a right. In it, or that there is a requirement of fulfillment of the right or that is order in order to violating references or in the case of having that here. This matter the court has laid down laboratory of exercise legal standards alternate remedy taken for under such circumstances we are court that when there is an express decision of bankruptcy under the Assam and more particular when the exception prescribed under law because of the that has not been completed in case negate evidence of site any such that by if such an appeal pursued then they shall decide by taking into consideration laid down by the judge of the head of and with judgment as either is followed in several sections of this court. This was Brigadier Alloy. And when the authority concerned may hear the matter decided and thereafter pass meeting, the authority will also take into consideration the option of the
4/2/2020. 4/2/2020.
or to
4/2/2020. Your Lordship.
of legal court when by the Department of Personnel,
Yes.
whereby the procedure for review of cases under suspension have been elaborately provided for the notification by executive. It is submitted as by the Learned Counsel, that is read up. Under such circumstances, consider fact A, the petitioner permitted file the appeal for the appellate authority in 1 week from the date of the thereafter authority the appropriate authority, namely commissioner,
Department. Revenue Department.
revenue. Be sure of the appellate authority.
First, I have to take a look. Now Principal Secretary, Commissioner, now Principal Secretary. Principal Secretary, Revenue Division.
Officers now, so there is a commissioner, also a principal secretary.
No, only Principal Secretary.
Each officer now be re-nomenclatured as principal secretary of Assam Guard. Of the appellate authority. Here the appeal and both of in terms of the direction indicated. For the purposes of this case, the petitioner desires by the writ petition along the included may be permitted by the and its authority in treating with an appeal thereafter as directed. The entire exercise is completed within 50 days from the date of notification. Any such order that pass copy
Obliged.
Mr. S. for Revenue and
Look, 1 and 2.
Mr. C. Hazarika for
Uh,
DC.
DC, your lordship. For 3 and 4, your lordship.
Yes, item 9.
Lordship,
Let's see the
next time may be allowed to file our affidavit, Lordship.
Affidavit. You received your instruction.
No, Lordship, they only verbal instruction that they are processing or the file they have sent it to the finance department. It's a verbal instruction only, Lordship.
How will you file your affidavit? Who is supposed to give you the instruction?
Or if it is a director, Lordship.
Why is it not given you instruction?
Lordship, till since our director was, the department, the director was not there, no in charge was there, that he's there joining on the 18th, Lordship. That's why some delay is there, Lordship. Only 1 week time may be allowed, Lordship.
18th of May. When is he joining?
18th of April, Lordship. The
Yes.
new director has joining April, from 3rd of April, no, director was not there, Lordship. He was,
He submitted that is director of the concerned department was has been joined the prototype of court by setting up veterinary department. Veterinary and animal husband. Sir,
A. Borwa. Lordship, notice was not issued for last week.
since the instructions are away,
Lordship, in the interim, provisional pension may be released.
it's the understanding of the husbandry and veterinary survey, however, furnished respect to the law. But the case
I
to
might.
be high is for the target observed for
Hi, ma'am.
five. Setting of the present however, extra but 1 week. The tendency of the repetition shall not be a bar for the law provisional
Provisional pension.
obliged, Lordship.
May please your lordship. My lord, this matter relating to the, my lord, non-payment of my lord, higher full pension, my lord. Is a government.
The water has flown down from the time Fazle Rabbi's judgment was passed in 2010. And now we are in the year 2024. The same issue, my lord. My lord, I'll just give a brief recap of the facts quickly, my lord. My lord, the year was 1972 when the Assam Panchayat Act 72 was in vogue at that period of time. Casual workers who were drawing a fixed pay were employed by the PRIs. My lord, left, right, and center, they were all employed by the PRI. 1991, my lord, what happened subsequently is that 4,565 employees who were employed under the 72 Act were provincialized in the year 1991 by the Assam Provincialization Act 1999 with effect from 2nd of October 91. Subsequently, in the year 93, they are regularized by creating that many number of posts with effect from 91. So provincialization takes place in 91, then post creation takes place in 93. Then this entire litigation in Fazle Rabbi starts. The stand taken by the state government is that the qualifying service starts from the date that is 2nd of October 1991 from the date of their provincialization. Whereas the stand taken by the petitioners therein was that it should be counted from the date of the initial appointment into the panchayats. So the court held that it should be counted from the date of initial appointment. It was challenged in the Supreme Court, SLP dismissed in limine, and Fazle Rabbi has attained finality. That was in the year 2010. 2024, my lord, the same question came up before the apex court. In a case, Doordarshan versus Maggi Desai. I have a copy of the judgment, my lord. Therein the same question that arose was whether the services rendered as a casual employee who's not working against any sanction post. So in this Doordarshan case, what had happened is that Doordarshan had inducted casual employees in the year 1985, not against any post, non-sanctioned post, casual and contractual employees. Subsequently, in 95, they are regularized by Doordarshan.
They are
So
not working against sanction.
they were casual employees, my lord. Casual.
Casual employee.
No, my lord.
I'll get into the facts later on. So in Doordarshan case, what happens is that they are all casual employees and they are subsequently regularized in the year 95 by Doordarshan. So these casual employees state that our period, that is the services rendered from 85 to 95, should also be counted as qualifying service towards pension. What
See, there is no quarrel on the fact that rendered under casual employee may or may not be counted for pension when it is, but Fazle Rabbi was not on that.
My lord, but from the date of their initial appointment
that's
till their date of their provincialization, they were not working against any post.
That we don't know, but Fazle Rabbi, that has been upheld now.
That has been upheld,
Right.
but the fact
Now-
is that, my lord, what these guys are doing now, that these are not they were not parties during the Fazle Rabbi's judgment. They were fence sitters. Fazle Rabbi has attained finality vis-a-vis the 136 petitioners who had approached the court at the relevant period of time when Fazle Rabbi was finally adjudicated. These new set of petitioners who have approached this court in the year 2023.
We to say that they are working as Gaon Panchayat secretary, casual matter. I mean,
Till provincialization.
Huh?
Till their provincialization and subsequent regularization, they were not working against any post. So the principles in Fazle Rabbi have
working against, you are not working against any post or you are not working.
any post, my lord. They were subsequently provincialized for the
How
first
are they working as Panchayat?
casual employees, my lord, temporary basis. And their appointments were also very illegal, my lord, because at that point of time when the act was in vogue, the competent authority was the commissioner, who was at that point of time known as the director PNRD, later redesignated as commissioner. But these appointments were made by the Gaon Panchayat officials, like the secretary has appointed him, who's not even a competent authority. And in fact, my lord, they have not even annexed a single appointment order here.
Regard to what it is,
Not a single appointment order has been annexed in any of the writ petitions herein.
My lord,
what do you say?
my lord.
What is your submission?
My lord, my submission is that, my lord, that it is a settled law, my lord. Fazle Rabbi has already settled the issue, my lord. The Panchayat employees, my lord, Panchayat employees, the appointment of the Panchayat employees are made by the, my lord, initially PRIs. My lord, subsequently they were paid, my lord, regular scale. Then, my lord, their service was provincialized, my lord. The casual employees of other department or other casual employees, they cannot claim because the petitioners is covered by the, my lord, Fazle Rabbi, and Fazle Rabbi has already settled, and it was, my lord.
Why did you not come at the time when Fazle Rabbi was there? Why did you not come
approach the
before
court
at the relevant point in time?
Well, because there was a, my lord, notification after Fazle Rabbi. Well, there is a notification, my lord. This pursuant to this notification, pension has been paid, my lord. My lord, kindly see, pays, my lord, pays, my lord,
The
for
question
60.
is, why did you not come to the court
My lord,
during the time Fazle Rabbi was there or immediately thereafter?
pursuant to the Fazle Rabbi, the petitioners are paid pension, my lord.
Petitioner,
So, my lord,
which petitioner?
but these petitioners are paid pursuant to the Fazle Rabbi.
Pension. They're given pension.
Yes, your lordship.
The only question is the counting of the earlier service.
Yes, your lordship. And that has been, my lord, accepted by the, my lord, to coordinate bench of this honorable court also, my lord.
My lord,
Kindly
far
see,
as-
my lord, page 65, the notification, my lord. Pursuant to this notification, my lord, the pension, petitioner is paid the pension, my lord.
Who was that relevant portion in Fazle Rabbi judgment?
My lord, kindly see page, my lord, page 62. Page 62. Page 62, my lord, last pipeline, my lord.
Yes.
My lord, we are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the date of the initial appointment. Initial appointment, have the petitioner initially appointed in 1967, my lord.
But there's a
So his length of service should be reckoned from the my lord, the date of his appointment, my lord.
Well,
initial
the
appointment.
number of petitioners in
Then, my
Fazle
lord-
Rabbi case is
Then,
136.
my lord,
As
then-
far as Fazle Rabbi is
then my lord,
concerned,
page 65, my lord, the notification, my lord. Over here, then, my lord, page 65. Notification, my lord, issued on 17 March 2011, my lord, pursuant to the, my lord, Fazle Rabbi judgment, my lord. My lord, para 2, my lord. May I read, my lord?
Yes.
Now, in terms of the judgment referred above, the governor of Assam is pleased to order that the benefit of the provisions of the Assam Panchayat Employees Provincial Resolution 1999, including those for pension and other retirement dues applicable to the state government employees, would be applicable to the provincial Panchayat employees who are in service on or after 1/10/1991 on the basis of the length of their service, reckoned from the date of the initial appointment in the service of Panchayat. From the initial appointment, my lord. Because the petitioner appointed only one time in 1967. Thereafter, no fresh appointment was issued, my lord. And provincial legislature is not a fresh appointment, my lord. It's only financial benefit, my lord. Then, my lord, this issue was raised earlier regarding the, my lord, ad hoc period shall not be counted. Honorable court already decided, my lord. Kindly see judgment.
but this judgment has attained finality vis-a-vis the 136 petitioners who had initially applied.
But question of law is applicable.
My lord.
Applicable, but it has been withered away by the subsequent judgment.
The judgment say
My lord.
that this judgment or the ratio of the judgment will be applicable only to the petitioner, that no further.
Well, that is the question, because the question of law that was formulated during the period when Fazle Rabbi
What
was
is the
being,
question of law?
the question was whether services prior to provincialization should be counted or not. The division bench held that that period should be counted, whereas the subsequent
In
apex court judgment has held that that prior period cannot be counted prior to regularization. That is what I'm
In
like
some
harping on.
case, my lord.
So, my lord, because of this apex court judgment, now Fazle Rabbi can't be touched because this has attained finality. 136 petitioners who were there in Fazle
No,
Rabbi.
what do you mean it can't be touched? You
Well,
write
touched as in it has attained finality, the rights have been crystallized, my lord, as far as these petitioners are concerned.
right may be crystallized, but then the law needs to be corrected, that will have to heard about it.
My lord, I'm pressing on it because this subsequent judgment of the apex court has actually overruled the principles on which Fazle Rabbi was passed. That is my humble submission.
Was from Fazle Rabbi, what are the facts? He doesn't say whether they are employed in substantive post or they're working in temporary post. Nothing.
My lord, the very fact that the petitioners have not been able to annex a single appointment order, the burden of proof is on them.
Where do you say that the petitioner Fazle Rabbi are not similarly situated at the regiment? Do you agree or disagree with that?
They're similarly,
They're
similarly,
similarly situated.
but since the subsequent judgment of the apex court is in vogue now, my lord, so the principles in Fazle Rabbi have been overruled now.
My lord, in my lord, Shamsher Ali Ahmed case, my lord, a para 4, my lord, they have raised that question that my lord, ad hoc period shall not be counted in para 4. But the honorable court, my lord, rejected their, my lord, stand, my lord. So my lord, this question, my lord, they cannot raise again, my lord. Already, my lord, raised, my lord.
So this question was raised, but the Supreme Court judgment was not there.
My lord, quoted, my lord. Para 6, my lord.
Where?
Of this judgment, my lord.
This is a new judgment.
Shamsher Ali judgment, my lord. I have given, my lord, copy.
Where have you given?
Para 4, 6, and 7, my lord.
Where is the Supreme Court judgment?
My lord, Soed Fazle Rabbi, my lord, put it in para 6, my lord.
Has this judgment been considered?
My lord,
This judgment? This
No, my
new
lord.
judgment? Which the,
no, my lord, new judgment is a different footing, my lord.
you have to address us on this. He raised an objection that with effect from this judgment, the law of Puzzler is not a law anymore. That is sufficient.
Because my lord,
You'll have to go to the judgment.
yes,
Tell us.
yeah, lord.
Our learned counsel.
My lord, may fix this matter at 2 because he has got similarly situated matters listed in the admission column as well. But
You point out, give the numbers, if these all the matters
My lord.
together. By the respondent. And the judgment lettered by judgment of the court is clear of the court is going no longer you back. The apex court lettered judgment lettered the director general to certain staff for India. That is REHI. Has held that services rendered contractual casual are not be treated as shall not be treated as temporary service and shall not be counted as services. The view of such objection raised again on tell us when
My lord, any date may be given, my lord. Next week, my lord. One, my lord.
16th of May.
similar matters in the admission list.
You submitted that the restrictions are paid also connected that
Number 2 details.
user for what?
Motion, my lord.
Motion.
It is still for admission.
Item 45, 46, 47, and 48.
Item 45,
46, 47, and 48.
46.
Well.
And these are what are these items?
Admission.
10 to 12.
10 to 12.
10 to 12 and item 46, 48. The club, sorry, 45 to 48. Club has for admission here.
Well, maybe kept as part of, my lord.
Not part. You the judgment and address the
My lord. Highly obliged. my lord.
for Panchayat, I have identified the responsibility for Director of Pension. Anyone else?
No.
Sir, your name, sorry, M. Islam.
M. Islam.
For item number 10 and 11 and NSR for 12
12 and 40.
12 and 40.
Highly obliged, my lord.
I'm sorry, Lordship, my lord, that item number 7, Lordship, was already been disposed of. The appeal, my lord, it should be, my lord, live before the response number 2, Lordship.
Who is respondent?
Is the director of my lord land record and service. Regarding Mondal, Lordship, my lord, that suspension is item number 7. Lordship was given direction to file a Picardy appeal before the principal secretary. My lord, it should be, my lord, instead of 1, it
Are
should
you
be
saying
2.
that the director is a higher authority than DC?
Lordship. Now, my lord, earlier, my lord, deputy commissioner was the appointing authority. Now, my lord, as per the, my lord, that new amendment, my lord, the director is the appointing authority.
So
Appointing authority, my lord, that's why, my lord, this appeal prefer, my lord, this earlier lordship, my lord, appeal is before the, my lord, director.
assuming now there is a change and appointment authority to the director. Who is the authority above the director?
It should be, my lord, second appeal should be before the, my lord, the principal secretary. Now, my lord, it is the, my lord, director,
There is only one appeal.
lordship.
Under the
After
rule-
the appeal, my lord, they can go for the, my lord, the principal.
under the rule, there is only one appeal.
Lordship.
There is no second appeal. So who is the authority higher than the director?
Higher than the director is the principal, lord.
Let me tell the principal thing. Because in any case, the director is the appointing authority.
Now,
So let the principal secretary appellate authority. Let the matter be decided. And more particularly when the indication is with the chief secretary. Let it be like that.
Lordship.
Yes.
Obligation.
May I, my lord? Here, I was directed to obtain instruction, my lord. But, kindly click on 29, my lord. So there is not yet a instruction.
Lordship,
What instruction?
My lord, here instruct headmaster, my lord.
Lordship,
I have
the order is
overtaken.
in my favor, Lordship. Annexure 3 and Annexure 4. I was
The judge
reverted.
is not allowing you to.
Yes, Lordship, that is the problem. And
So why is it not allowing?
But,
How much time do you require to get that information?
my lord.
Lordship, direction.
He was transferred on 5/9/2023
Not
as a
transferred.
assistant
This is not transferred.
on Annexure 2, my lord. He
This
was
is
not
not transferred.
due to some public interest, my lord. So, my
It
lord,
was
there
not
is something
transferred,
there.
Lordship. He
My lord,
was
kindly
attached,
click on
Lordship.
29, I'll obtain instruction.
He was attached, Lordship, and revert back, Lordship, again.
No. Where is the order you are complaining of now?
Lordship, every order is in my favor, Lordship. Annexure 3 and Annexure 4, Lordship.
So after Annexure 2, there is an order of Annexure 3.
Annexure 3, Lordship.
So Annexure 3 is you are reverted back to their original post.
Lordship. Then, Lordship, Annexure 4 is the specific order, Lordship, by the BEO, Lordship.
So what was your original post?
Original post, Lordship, IC Headmaster, Alipukuri M School, Lordship.
But he was transferred on 5/9/2020, my lord, attachment just on 29, my lord.
And the only problem is that, Lordship, Headmaster, present IC Headmaster, Lordship, he refused to give me charge, Lordship. And in fact, Lordship, he has no authority, Lordship, no power and authority, Headmaster, Lordship. After BO and DC's order, Lordship, he has no power. And he refused to.
A question of implementation of.
Yes, Lordship.
You are appearing for.
I'm appearing for deputy.
What role do you have?
My lord, initially, annexure to page number 16, my lord. That order, my lord, charge was given original school, my lord, to other person, Akhtarul Haq, my lord. Now charge was given to him, my lord. In that, my lord, attachment order, my lord, that instance has already gone, my lord. Because, my lord, that is not saying that new school, my lord, he is allowed to work as an assistant teacher only, my lord, not as an in-charge headmaster.
Lordship, may kindly go to Annexure 4, Lordship. Regarding hand over the charge of headmaster.
Annexure 4 is clear.
Yes, Lordship.
Annexure 4, my lord.
And Lordship,
issued by the DO, my lord.
Annexure 3 is the, Lordship, a common order, general order, Lordship. It's not specific to the petitioner, Lordship, only. And specific order is Annexure 4, Lordship. And BO is also, order is also in my favor, Lordship. Only the.
Who is to pass the order?
Lordship, BO can, Lordship.
Who has passed your order or initial order of
DEO Lordship,
DEO, my lord.
DEO, District
Page
Elementary
number
Education.
16, my lord, issued by the DEO, my lord. Subsequently, Deputy
then
Commissioner.
why the district commissioner is
My lord, subsequently, District Commissioner issued by lord page number 17, my lord.
why?
My lord, they are saying that there are other single pieces there, my lord. But some pieces attached with other school, my lord. For
Lordship,
rationalization.
it was an initial internal arrangement by the DEO, BEO Lordship. And when this fact came into the notice of the Lordship, District Commissioner Lordship, and regarding transparent posting of Lordship, this teacher of elementary and secondary school Lordship, District Commissioner is the authority Lordship. When this fact came to the notice of the District Commissioner, he issued this order dated 21/3/2024.
We are issued, my lord, on 21/3 order, only because of, my lord, some school is running only single teacher, my lord.
So your order is on 21/3, you are asking people to
Yes.
go back to their original post.
My lord.
So she wants to go back,
My lord.
but the person concerned is not handing over.
My lord. That, my lord, DO has issued a letter issued in page number 18, my
That is
lord.
what we want to know, why it has not been complied with.
My lord.
Then you are asking for so much of time, why?
There is something is there. My lord.
What something? You are going to pass some other order.
No, my lord. No.
By 29, you are going to say this order is gone infractuous, new order has come.
No, my lord. No.
You get it by 2 o'clock.
My lord, no,
No,
29, my
2
lord.
o'clock, 2 o'clock today.
I'll call you on Friday, my lord.
Not Friday, today.
Because my lord, the election.
I am Lordship.
No election business. Or we are dismissing, we are directing the director to implement it immediately. 2 o'clock, 2 p.m. What is going on?
My lord, tell you on tomorrow.
No, why? Why? Tell me why. What is that? I take about tomorrow, day after, and 29. Why? You have to just give, you have to give the instruction to the court as to why this order has not been complied with. That's all. Can they not give you that instruction? Get it at 2 p.m. Yes. So, yes,
My lord, the petitioner has been serving as director of Digrugarh University Technology since 1/11/2012. My lord, in terms of All India Council of Technical Education notification dated 22/1/2010, which stipulates, my lord, the principal or director, they are to be placed in a payment situation where, my lord, he has been deprived of that payment. My lord, he has been given scale of 13 in place of scale 14. That is our case, and some of the condition of service has already been violated. So we are against that matter.
Appearing on behalf of R. Mazumdar, my lord, let me have some instruction. Instruction. I need instruction.
you need or you have.
I don't have instruction. I need instruction.
You are not agreed with AIC.
We are not agreed with the AIC.
You want the AICT norm to be implemented.
Exactly, ma'am.
Third, this petition is filed by the fact that he has not been given the revised scale of pay as
Ma'am.
per the AIC norm. Have you represented before the authority?
Yes, yes.
Representation.
Annexure 3, 4, and 5.
According to court filing. That I noticed that 4 weeks. Mr. R. Mazumdar appeared for Digrugarh University. The representative responded the representative to the weight of the 1 week. Had to be gifted after the grant date. The file in city council. By addressing the information of the part, it redress.
Not
Letter basically pertains to non-payment of period salary, my lord. He had earlier approached this court, my lord, that court had reacted to them the claim, my lord, but they had rejected, my lord. If by the impugn order, my lord, case 79, my lord. My lord, it is not applicable in fact to the petitioners, my lord. They are referring a cabinet memorandum dated 7/10/2020. Here they have raised some categories of teacher, my lord.
You are all the illegal, irregular teacher.
My lord.
You are the illegal, irregular teacher.
Yes, my lord. And our service was regular.
Now, Mr. Sharma,
Lordship.
if you look into the, you are agreed by the order of 79,
79, Lordship.
7980.
This was passed in compliance to the earlier petition, Lordship.
2023. This order was passed on 25/7/2020.
What was the direction of the court?
Well, the court's direction, my lord.
Court direction was page number 77 is the operative portion, Lordship. Accordingly, we are of the view that it would be a fit case for the petitioners to make individual representations before the Secretary to the Government of Assam in the Elementary Education Department, enclosing all such documents, testimonials that they have to substantiate their names were also included in the list of 2776 numbers of teachers referred in the order dated 9/8/2005. If the petitioners in their individual representation can satisfy the said aspect, a further exemption would be required as to whether they are still working so as to entitle them to salary and allowances. Upon undertaking such an endeavor, a reason order be passed by the authorities on the individual representation that would be submitted. The reason order be passed within a period of 30 days from the date of receipt of the certified copy of this order, and the authorities would be under obligation to pass a reason order only in respect of those petitioners who submit their representations pursuant to this order. If the representations are not submitted, no further obligation shall remain with the authorities to pass any such order. Pursuant to the orders of 9 so and so, if the persons whose names were included in the list of referred therein are required to be subjected to any further process, the petitioners be also subject to such process, if their names are also included in the said list. But in either view of the matter, the representations that may be submitted be brought to its logical end by passing a reason order in the manner as indicated above. So, in compliance to this order, Lordship, this speaking order has been passed, where it has been reflected that they were within the ambit of illegally and irregularly appointed teachers.
No, but what is the meaning of this decision? You look into the order.
Lordship.
The findings.
Findings, Lordship.
No, the findings are not with regard to the petitioner.
Yes.
Findings are general. General findings. And the decision said that they are they have fulfilled the criteria related to illegal. In what sense? How? Nothing is discussed.
Lordship, during the period of 1991 to 2001, Lordship, 1989 to 2001,
You are
Lordship.
not there.
Lordship.
From this order,
Lordship.
you may know because you are posted with instruction.
Lordship.
How does an ordinary person understand what is the meaning of this encrypted order? Cryptic order. Reflecting the decision. Page 8. What does one make out?
Because this order says that those teachers were illegally and irregularly appointed teachers, and accordingly, an screening committee was constituted. They were subject to screening in the screening committee,
But
Lordship.
where does it say that their names not appear in list 1?
Lordship.
Where does it say?
In page number 80, Lordship, decision.
Yes.
From examination, it is seen that none of the petitioners in this instant case
have fulfilled the criteria as laid down in the cabinet memorandum related to illegal, irregular category.
What is the meaning of that? Why not say that none of the criteria, none of these petitioners' names are found in this one question?
Lordship,
That could have been very
Lordship,
simply said
Lordship,
instead of giving such a
Lordship,
reply.
Lordship.
Why? They have not got salary nor had any kind of training.
No, because to be eligible to be accommodated as teacher, they have to receive salary up to 2007. And they should have a minimum basic training. And to be eligible for accommodating as a tutor,
Therefore, they fall under list 3.
they fall under list 3, neither receive salary nor they have a
So,
basic training.
where is the decision saying that these 3 candidates are not to be not to be nothing? Where is the
Their names are not reflected here.
not name?
No.
From the cabinet to
Lordship,
those falling under 3
Lordship,
are excluded.
Lordship.
Where is the discussion?
The court has reacted to them in the push that their names were included in the list of 2,776 number.
Then petitioners were directed to file individual representation.
Individual representation. They file representation. Now, upon verification
Reason order is to be passed by the authorities on individual representation.
on individual representation.
So this individual representation will have how many petitioners are there?
In this case, 3 met. 3 petitioners.
3 petitioners.
Here, 3 petitioners clause. Otherwise, Lordship, issue notice, Lordship, we will give the detail.
No. To clarify why this order is not be interfered.
Lord.
Or we set aside and ask them to pass the pressure.
Also, I will obtain instruction.
Hard learned counsel. He regards the petitioner that direct ID order date 5/5 pass.
2009.
Director to part.
Para 11.
A liberty was granted. Thereof, this order was passed on these council that order date
25/7/2020.
25/7 pass. Rejecting claim. Being
Elementary.
elementary order has been passed. That petitioner is very high. It should represent it. Does not direct path this order, but reason order. But take care of the order
25/7/20.
that also some kind of recorded and arrived by second here. Primary facie does not appear have been in terms direct passing recent order, the earlier order.
Okay.
This
Plus extra
Sharma has entered clearance. Uh, the extra copies we find. In a bit, one week.
Publish.
Yes, your affidavit is clear
Lords,
to be closing,
Lords.
but Mr. Bora submits that
The 7 lakh gratuity amount should have been released immediately.
amount should be released immediately.
This is the case. They should have been
Release the gratuity amount.
Lords, in compliance of this Honorable this High Court order, there are so many similar matters are disposing, and we are taking responsibility per month 10 lakhs, Lord.
Where is that order?
Lord.
Any
Yes, Lordship, there are so many orders, Lordship. I'm relying on order, Lordship, passed by this Mr. Honorable Justice Mr. D. Borua, Lordship. Similar matter, Lordship. There are so many such type of similar matters are disposing, Lordship. Para 6, Lordship. Para 6, Lordship.
time frame at least.
Time frame, my application is clear regarding time frame.
With 7% interest, man.
Lord.
And what is your statement in the affidavit?
Actually, in Parastic manner, they will pay in 12 months.
Yes,
After I will release the amount of 1 lakh 2,000, thereafter in 12 installment, subsequent 1 lakh installment, they will release the amount entire.
But there is no mention about interest.
Interest is not. Now they have to pay interest in the situation.
Lordship.
Is this order good for you?
Lordship, they let the pay in 12 installment with interest of 7%.
Okay. Yes. Yes, this
No. In 12 installment.
whatever the order is.
No.
Whatever the order is.
One of my
Whatever
amount.
the affidavit says, sorry, along with 7% interest.
Lordship. Lordship.
Mass of blessing.
Maybe, Lordship.
Yes.
Lordship, madam, maybe we will pass over for timing.
Huh?
Pass over for timing.
Typing.
Kindly, madam, may fix 2 p.m. Lordship.
Typing. Dismiss.
May I please, Your Lordship? Lordship, infractuous matter may be closed.
Is submitted by Mr. P.
So for the health department.
Health department.
What's all that?
Pending either. Yes, have you released?
Yeah, well, here we were supposed to place the supplementary budget proposal, man, that has been clicked, man.
Do it to her. Don't do it. Do it to her.
It was sent only on 22nd of April.
It has gone to the director. Now, how many more months will the director take? Why have you sent it on 22nd? When the order was passed on 3rd?
During, there was Bihu vacations and all.
Oh, you have time for Bihu and you are not releasing salary for the person, the employee.
For that, we need the
How
supplementary
many,
budget.
how many days of Bihu vacation was there? And when was the Bihu vacation? His order was passed on third.
And within 2 weeks, it was supposed to be sent.
Huh.
That, and we have sent within 2 weeks.
Who's for the director handloom? Handloom and textile
Handloom has
is-
not been made apart.
Where is Mr. Ross? It's submitted by the Learned Standing Council that the Chief Executive Officer Assam Hardikar Village Board has requested, has sent a proposal for a retirement benefit. Has sent a supplementary fund proposal to the government for sanction of the entire time. So the amount comes 80,90,1. They request the communication indicates that the government is not so but so like permitted further time right for further step to take toward the sanction of the supplementary demand. Have you sanctioned?
My lord, that instruction, this is on 22nd only they have sent this month.
How many more weeks?
My lord, sanction, we do not, my lord, we will send it to my lord, finance department.
So how will you pay?
My lord, let this come up after 4 weeks, my lord. And
4 weeks.
my lord, because of model code of conduct, nothing is moving regarding finance, my lord.
This is under orders of the court. You are doing it under orders of the court.
But my lord, we do not give sanction, my lord. We will pass it on to
That's
finance
right.
department.
So you pass it on. You do your job. You
My lord,
complete your part. That's why
let it come after 3 weeks, my lord. 3 weeks,
1 week. 1 week.
2 weeks.
You are bargaining before the court.
No, it's not bargaining, my lord. I'm trying to buy some time for my department even, my lord.
Why? Maybe they don't want.
No,
Why
no,
are you
no,
so
no, my lord. My lord, there is nothing personal in it, my lord.
Of course, there is nothing personal. But why are you worried that the department will not be able to do it? Seems to be not
No, my
very
lord.
high hopes of the competence of your department.
No, my lord. We are very now short of manpower. Those who have gone for election duties and all, my lord. So we are working in a very thin, ice thin. That is the thing, my lord.
The finance department is also party. Lord, you may direct the finance department also to expedite the
So
matter.
they will say that we have not received.
Yes, after receiving this.
First, let it go.
Yes.
Handloom and textile department is directed act upon the supplementary demand positively within weeks from today. Copy of this order be marked Mr. R. Todd. The race will be held on account of the department. Appears to file department directed pass this order
Please,
from the department. Is after copy.
Date name.
20 May.
My lord, my name may be shown in the call list, my lord. I missed, my lord.
Has hold hard hold may be reflected
SC handloom and textile will do that.
indicating handloom is setting up textile.
No, my lord. I missed, my lord, because my name is not there.
We have done everything. that
My
we
lord,
want.
thank you. My
Now
lord,
you have-
oblige, my lord. I bow down.
Whatever is
I
required.
bow down, my lord. Before the lordship. I just bow down, my lord. Much obliged.
May please your lordship. Lordship, this case, may I pray lordship kindly take up the matter after some time, lordship. My senior will argue this matter, lordship. Oblige.
My lord, in item number 19, we have received some instructions. Kindly some time may be granted, we'll bring it on record.
Which department?
My lord, cooperation department.
Cooperation department. Order type. And I, we have.
RB Goswami, my lord. Formed Miss MD Bora. My lord.
Oblige.
Oblige.
Legal lordship, this therefore release of leave salary. My lord,
Yes. Reported.
So, extra copy yet to serve, lordship.
Oh,
Lordship.
no, third.
I have been sir,
No, lordship.
already given, my lord.
Give him one. You give him one.
One more.
And people
Right.
stop.
My lord, the case be listed on.
Within working days.
Next step is my lord.
You first give him the copy within days. Then it can.
Today I will give. Today I will give.
It's a week beginning from 27. 27. Yes. Yes.
My lord,
Counter
matter
evidence.
related to area salary, my lord, some time was sought for by the standing council education meeting.
Yes.
None appeared.
Education.
My lord.
Secondary.
Secondary. Affidavit is required, my lord. That's why matter is pending long, my lord.
Why no affidavit is there? Who's for secondary education? The air Mia appears.
My
As per the last report, see that secondary report type 5 complete their instructions and file necessary affidavit. However, such affidavit is filed. You don't want to file affidavit.
We want to file affidavit, lordship. Mr. N.J. Khatiner will be appearing in this matter. Lordship,
Whatever is appearing.
lordship allow some time, lordship.
As a matter of last opportunity, grant further 3 times.
Lordship.
File their affidavit. Taking the liberty to file affidavit.
Okay. Bless.
None appears. The name of D. Bhattacharya.
Respondent 780.
Accountant.
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 Respondent number 2.
My lord, matter pertains to non-payment of family pension, lordship. Lordship, may kindly peruse the order dated 22/11/2023, lordship.
Lordship, here I need some time to obtain the updated instruction, lordship.
As per the order dated, my lord, 22/11/2023, my lord, there was a direction for, my lord, release of, my lord, provisional pension, lordship. And they have not, complied with the order.
Lordship, the provisional pension, lordship, papers have been moved, lordship. It is in the government, lordship.
Why the regular pension?
Lordship, because lordship, since the year 1998, lordship, we suddenly
disappeared, Lordship. He never came back and worked in the department, Lordship. And there was no records to be found in the department, but we got it from the office of the AG, Lordship, and then we have processed. And Lordship, he came before this court only in the year 2022.
When did you superannuate?
Yes,
When did you superannuate?
but on 2005, 2005, Lordship. And he came to the court on in the year 2005.
2005.
And since
Why has it come to date?
My lord, he was a cardiac patient, Lordship. Lordship, in the year 1998, Lordship, he sought for Lordship medical leave, Lordship. And Lordship, in the year 1990,
Whatever it may be, if you are not getting pension since 2005, you are coming now. 20 years.
my lord, thereafter he approached Lordship. After surgery, Lordship, he Lordship approached before the authority to join Lordship, but he was not allowed to join Lordship. He was a Lordship cardiac patient, so Lordship he could not move to Jorhat Lordship frequently.
Here, no. Someone has filed some affidavit here.
We have filed affidavit.
Lordship, we have filed, Lordship, but subsequently, Lordship, we have received the records from the AG office, Lordship, and we have processed for the provisional pension, Lordship.
Why so many additional affidavits? What have you filed?
Lordship, there was substitution also for legal heirs, Lordship, because he expired.
Why have you filed additional affidavits? 3-4 additional affidavits.
My
Why?
additional affidavit was filed, Lordship, as per Lordship, High Court order, Lordship, additional affidavit was filed, Lordship.
Lordship, to implement the finance department, Lordship.
One, Lordship, to the finance department, Lordship. Another to Lordship.
It is submitted by the study of health department that it grant of health to the health the relevant report have the office of health department subsidiary.
Whatever record is required already you have submitted.
Study of right. The right. Respondent that affected by more legal factor. Not responsible to the health department. Right. Department to provide again 29.
Highly obliged. Highly obliged.
Right, please, Lordship. Lordship, in this matter, we have received instructions, Lordship. We'll be filing an affidavit.
Yes.
Otherwise, my lord, the case is covered.
General Administration Department.
Praise for how
My
much
lord,
time?
2 weeks time.
Weeks time.
May kindly fix the date.
The affidavit be filed.
Otherwise, my lord, it is covered under the Upinda charge. Let him file the
Still
affidavit.
filed.
Okay.
Deeply obliged, sir.
Much obliged.
My lord, can you see the last order, my lord, dated 5/2/2024. Non-payment of retirement benefits, my lord. So 3.5 years gone, my lord, petitioner has been retired from service.
Our matter may be disposed of with a direction to the commissioner to verify the service record of the petitioner
and whatever dues are pending and payable to him, be released within a period of 3 months from a date of receipt of copy of order. My lord, verification is important, that's all. Accordingly,
Who
whatever,
is to verify it?
well, let the commissioner do it, Commissioner PNRD.
Yes.
Since it's
Well,
pending for the last 3 years, as my learned
My lord,
senior said.
what verification is necessary, my lord?
So whatever is the service records,
You
leave.
call for the instructors. Why it has not been done?
My lord, I have recently received the instructions. I have received the instructions.
What does it say?
They say that he is eligible for leave encashment. He is eligible for DCRG. So they are actually processing it. So as far as the pension part is concerned, that he won't get. That is not even his
Pension part, I
prayer.
am
That
not
is not
claiming
even his
pension
prayer.
part, my
But
lord. I am not claiming pension
not
part.
pay-
Other retirement benefit.
DCRG and leave
Death cum
encashment.
retirement gratuity.
You're receiving your pension.
No, my lord, that is the another case is pending, my lord. The association has filed a case for pension.
Let the commissioner verify and pay.
My lord, I am on the death cum retirement benefits, then my lord, leave gratuity, insurance claim, etc., my lord.
What I'm saying, let the
Kindly see my
commissioner verify
prayer,
and
my
pay
lord.
it.
Kindly see my prayer.
What orders are passed with the other?
My lord, in the DRDA employees, my lord, they have filed for pension. That writ petition, my lord, I am not aware of the exact order of that. That case is pending before the government, my lord. That's so far my knowledge goes.
That case is pending before this honorable court. The department has taken time to file an affidavit. The question is the question in that particular writ petition is whether the services rendered as DRDA employees prior to absorption in the state government should be counted as qualifying service towards pension or not. That case is pending, my lord, and even in this writ petition, he has not sought for pension. He's just seeking leave encashment and DCRP. Accordingly, let the commissioner verify, and post verification, whatever amount is due should be released to him within 3 weeks, 3 months. No point like keeping this
It is
matter
filed
pending,
in
my lord.
22, September 22, my lord. They are taking time for, always taking time for filing
I'm
affidavit.
saying disposing it off.
Submitting that the matter be disposed of the director commissioner verify. Is it agreeable to you?
Within a stipulated time, my lord.
Heard. The point is that you have time. After the journey, happy. Breathe. Then breathe. Breathe back. The after the department or the employees of the various club and the club join as with permission or at the RTA subsequently put it with diet responsible authority directly like even group are required to have not been and reason therefore it was body by better department was several at a matter having another computer and where some examination if how wave or due anyone submit anything more? You are appearing for Karbi Anglong. Anything to submit? Huh? Keprai, Keprai. Karbi Anglong Department. The matter is under Panchayat court of the Commissioner of Panchayat.
Insurance, the general insurance,
Group insurance.
group insurance,
Benefit.
group.
Claim are her, but not with the authority of and all and thereafter pass respect to the give up verification without burden. Direct 30 days from the date of
30 days would be a bit less, at least 2 months.
30 days. Okay.
Yeah.
And there is the earlier order, 10/4/2023. This honorable director to receive instruction, madam.
Council for the BTC, it was a fixed time.
Which for 53?
Yeah, there was P Nayak APR.
No.
53.
P Nayak APR funded away. I don't feel eligible for it, no. Cover it.
Accountant to the parent account. Why the benefits are not been
Lordship, this matter has two parts, Lordship. One, as per the regularization order, he should have retired in the year 2008, but he continued up to 2017.
He then, retired in the
That is
2008,
one, Lord.
also covered, madam. Sanjita Roy, madam. For more than 20 years. But,
whatever it is, what
Lordship, one affidavit will require.
cite your affidavit. Learned counsel for the response of the time. Yeah, but
Finance.
historical for pension. Study how to
Right, in this case, the petitioner filed this application for non-payment of her salary from my lord, September 21 to my lord, December 23. Then, my lord, after the filing of this case, my lord, she has received salary. Presently, she is receiving the current salary. And regarding the area salary, she has received from March 23 to December 23. But she is not getting September 21 to February 23.
who is to release the salary? Who is supposed to release your salary?
The director, my lord.
Yes, director.
My lord, it is under process, Your Lordship. We have received the proposal from the IS today, Your Lordship.
Today they have taken time to, my lord, to submit the, my lord, up to date instruction, my lord, as per the last order, my lord, 19.3.
And what about the food? Anything to submit?
Lord, in fact, we have already forwarded, my lord. So it is in the, it is the director, my lord.
Pardon. The remark the for area salary. For which period?
Now, my lord, from September 21 to February 23.
September 21, February 20.
February 23.
Current salary.
Yes.
There are setting up
For
second or
secondary.
Education, Your Lordship.
second submit that proposal for
We have received today.
pay from
We have received it today, Your Lordship.
From the inspector of
From the inspector of school, Your Lordship.
the inspector. Will be processed and thereafter the orders have start in the school.
R4 and R5.
According to the reading.
My lord, kindly date may be fixed.
Reading by for the price report and for areas. Third June.
Mine.
Third of
Mine. Deeply obliged.
May I please, Lordship, my lord, the leave salary and my lord, area revised pay has not been paid to the petitioner, my lord. Kindly see the page, my lord, last order. my lord. 6274. Let's say, taken my lord already two,
Well,
three days.
this matter also may be disposed of with a direction to the BDO, concerned BDO, wherein the petitioner was employed to submit the proposal of the dues to the office of the commissioner within, say, 1 month, and accordingly the commissioner can.
You call for the record.
I have the records, madam.
No, you call for the proposal or whatever there. Call for. Why
Well,
should
the
we direct-
proposal is.
We can direct examine it
Yes.
by the commission. But
Well-
why should we direct the subordinate of
Well, it is with the commissioner's office only. Actually, there are two parts. His prayer is at page 21, madam.
Yeah.
There are two parts to his prayer.
leave salary?
Leave salary and arrear revised pay.
Hmm.
So, my lord, the commissioner may verify the service records, and accordingly, whatever is payable can be paid to the.
Provided the proposals are there.
Provided the proposals are there, he has sent it for re-verification to the BDO's office. So, if time is given, say 3 months or 4 months, so accordingly, the entire exercise may be completed, and a
Yes, what is it?
yes, speaking order may be passed.
Third, praying for a direction. Seven. Zero. I think career guys effect 28. The was point as an accountant in Sally. I already did 48,000, 41,000. Were transferred by common order. So he was transferred to since the petitioner's wife was suffering from terminal disease, it has applied for modification of that about the petitioner had suffered suffered the condition, resulting in the not being able to join. Relevant function of the court. The punishment was penalty was imposed. Subsequently, I think there are too many complicated facts.
Well, that writ petition, the earlier round of litigation has, that has run its course, my lord. So that,
No, but there appears to be a punishment imposed.
but this particular case is only limited to two things, my lord. That particular first round of litigation, that was in his favor. So now he's basically seeking the benefits that should have accrued to him if not for the first round of litigation. That is his limited prayer in this litigation. So whatever did not accrue to him because of the first round of litigation, that is what he's praying for. Let the department.
Why did it not accrue to him? Because
He was the first round of litigation.
My lord, can you see page 47, my lord? Page 47, relevant portion, my lord, of the order, my lord.
Yes.
Two increments, my lord, the impugn order dated 30/9/2019 was set aside.
Huh?
Page 47, my lord. The, my lord, the impugn order whereby, my lord, petitioners in two increments had already been.
That has been
Set aside. So now he's seeking for that.
being agreed by the right. 526. Dated 6/10/2025. I think.
The speaking order is at page 48.
Interfere, please. the order dated 33/2019, by which the departmental report that we provide and view of the order passed, view of the order dated passed by order by and in view of interfering the order now having leave salary amounting to 763 and area by the from 1,400 crowd they that interference of the order of punishment by ordinary they repeat for her claim in the suspect. The direction DNR examine and there are speaking for in order to decide the matter, any information required or any subordinate of the that is to be carried out. You know, you know,
Obliged.
But last occasion, Lordship was pleased to give time to for filing the affidavit by respondent number 1, 2, and the others. My lord. Only the 3 has filed their affidavit.
My lord, I'm appearing for respondent 3. We have filed our affidavit.
what is the grievance?
But the grievance is the petition.
My lord, giving up my lord the UGC scale, actually he was appointed in 1994. At that time, there was no provision of the late slate or any PhD or MPhil except the 55% mark. But that was the condition put on the time of my regulation of service that I should be only entitled to this scale subject to declaration clearing of this qualification net and plate or
What is the stand of the UGC?
My lord.
My lord, the stand of UGC here is in 1991 for being appointed, if your lordship kindly has the affidavit, to be appointed as a lecturer, the eligibility criteria in
Like
Arts
eligibility criteria, UGC was that they are introducing the net and slate there, but in state of Assam, that is applicable from 2009 only. And at the same time, whenever the other lecturer appointed in the same college, that condition was not given. But circumstantially, my lord, that condition was put to me at the time of regulation. Probably certain circular style copies at the time of circulation, that way appointment was regularized and given. So some mistake was there. That is the reason that why that condition was still there. So
But-
although I have been given the scale of 2007 after on clearing, but I am entitled from the day. So because at the same time, 1 month before, and simultaneously appointed in the same college, that condition was not there. In the all entire state of Assam also, that condition was not there. In my case, that was there.
Yes.
Lordship, I need some time to construct the file and Lordship to get my instruction, Lordship.
The affidavit, my lord, is 1 and 2, that is, my lord, very mandatory, and they have to file. Otherwise, it is very difficult to take the decision on the basis of the UGC affidavit.
file up. However, done it, and file the file. Let the applicant let the study of the file. The file. It's after.
Lord, the appearance may kindly be recorded, ma'am.
Yeah.
My lord, date is given, my lord.
First of June, 3rd of June.
3rd June. Highly organized.
Obliged.
Master lord.
Ask this matter for the time being, Lordship.
Lordship has on last occasion directed to produce the record. It's a transfer matter. I have received the records, but the
What bring
True.
passing
true. But
pass it over.
kindly, but for the time being may be difficult to develop. Kindly, but there is a matter in court number 1, my lord. Kindly, I have received the records, my lord.
Tomorrow we'll have it
Tomorrow.
Lordship, not tomorrow. Tomorrow, RKD is not available, Lordship. At 2, Lordship, or day after tomorrow.
That will be
Right, we'll have it today only. You free yourself, whatever is there. follow.
Highly.
If it is convenient for you, you appear or you request one of your colleagues to be present.
That's two.
Second half.
Item 32, Your Lordship, affidavits have not been filed by the respondent.
So instruction received also will be filed within 2 weeks.
Turn it up. Yes, for father. Turn it up. Turn it. Turn it.
Obliged. Patent non-payment of compensation of family pension. The husband of the petitioner died on 7/10/2020.
Any instructions?
My lord has disposed of a similar matter in the past. My lord, I have a copy of the order.
Yeah. Let's have a
Dada. Similar matter. Mamuni Bauta. Wife is seeking family pension.
Yes.
Shared a copy. Same counsels, my lord.
Take Malad, it is a Malad, the case of the petitioner is compassionate family pension. In case
Family
Malad
pension.
Same, Malad.
Same word.
Other was covered Malad.
Here it is the case of compassionate
Family family pension.
pension. And in this case it was
Family pension. Both the cases family pension. Family
they heard this matter. The family pension.
No, Malad, it is the compassionate family pension. And covered case is family pension. Obliged.
Yes.
Next is allowed. Where the petitioner's pension has been stopped in spite of the honorable court's order. So Lordship, initially the petitioners were granted Lordship retired pension Lordship. Then thereafter, challenging the premature retire, the petitioner had approached the honorable court. And Lordship, the honorable court has directed that premature retirement is illegal. So he should be given Lordship the superannuation pension. Lordship, case Whittaker's order is there, Lordship, case 27. Out of the page 27. It starts from page 27. And the relevant is Lordship, paragraph 13. Paragraph 13 will be page. In terms of paragraph 13, Lordship, page 37 is the relevant.
Paragraph
Paragraph 13, page 37.
37.
Okay. This is the order of the Honorable Court to grant them superannuation pension.
Right.
And they have admitted that they will give, but with a condition that I will have to refund the amount that I was receiving as retirement pension. Then only they will give me the pension. Okay. Page 37.
You adjust the amount.
That is
My
the question. We are
lord,
saying.
my lord, in terms of the last order, my lord, we have received instruction. My lord, the difficulty is that, my lord, the authorities are unable to develop the mechanism, my lord, how to deduct, my lord, because
But that does not mean that they stop my retirement pension until since August, we are without a single penny. Our pension has been stopped. They are repeatedly asking me that, you come and.
What do you mean they are unable to divide? You are known to deduct amount from the pension, per stay and wrong declaration. What do you mean you are unable to divide?
my lord, we have written it to the Ministry of Finance, my lord, page 3, the third page, my lord.
No, but you can't withhold the pension. You can't divide. You don't divide, but you have to keep the pension. Till the
My
time you find a way.
Yes, sir.
My
You
lord.
can't do that.
Since August.
Direction of the court.
They may continue giving the retirement pension, lordship. They, in the meantime, they check out a lordship. They should check out a.
What amount are they required to?
All pension every day at page 40. Page 40 is their direction.
No, no. What amount do they want you to refund?
My pension, retired pension that they were giving me, all the gratuity, everything that they have given me on my since 2008. Okay. They are asking me that you refund us first, then we'll start the superannuation pension. And they have stopped my pension from August.
What is the difference?
Difference amount that is not
calculated.
They will have to calculate it. They will have to chop it out. Till they till they lordship check out a mechanism, lordship, they should not stop the pension since August. Now, lordship, they are without any single penny. Page 40 is their direction. They are saying that they will give. They have admitted that I have been notionally lordship reinstated.
You have fought for clarification on 24th of April.
My lord.
Yes, sir.
What
Order
are you
was
doing for all these days, all these months?
My lord, the order was of 11/3, my lord.
No. The order of the writ court, the division bench.
Yes, sir.
When was the order passed? 18-1.
Yes, my lord.
So what were you doing for more than 1 year?
They have stopped the pension. That is the vote they have done.
Then you suddenly wake up and decide that, okay, let us seek for a clarification which will never come. Isn't it? You have sought for a clarification
Yes, my lord.
to the Ministry of Finance, knowing fully well that it will never come.
No, Lord, it will come, my lord, because we have mentioned it as a, my lord. Lord will give us, my lord, some time. Otherwise, my lord, it will create further complications. My lord, if the direction is given to, my lord, will, in terms of the communication, my lord.
Hard learned counsel party, eight, learned. It's what education from that in respect of superannuation pension in favor of the clarification sought for the Ministry of Finance Department. In view of the imbroglio caused by virtue of the fact that earlier the pensioners have been released their pensionary benefits, being investment commutation and monthly pension. So, the respondents have sought for instruction to finance to intimate any rule of policy for adjustment of coverable pension benefit from the area and pay and allowing carry out the direction of the court in the direction of the court in the direction of an amendment by whereby the respondents have been directed for individual benefit.
Really super. And all other benefits.
And all other benefits. Considering subject in week's time. These will never come. It's
Not
for you to help yourself. If you want to point out the relevant portion of the your suggestions will not come. It will remain like that.
But in the meantime, may I pray that the retirement pension that they were receiving since 2008, that should be continued. They have stopped that.
They
Now,
have
what
stopped there,
authority?
they have stopped there because they want to give you. Now they can't give you because you are not returning back.
Lordship, I have
Now they are unable to adjust because they don't know what to apply.
that is not.
Right?
Lordship, at least after releasing the
You
superannuation,
was from the root book, what is the replicable? You pass on the code.
if they release the superannuation pension, then they may adjust it from my pension.
This is exactly the area where they seek information that there is no rule permitting adjustment. But you can show us from the book. So that instruction, something else, something, there is a hunch that their instructions never come.
No.
Find a price.
But till then, Lordship, can it be that the retired pension may be continued?
Wait for 2
Yes, Lordship. Lordship, a date may be fixed without pension since August.
27th of May.
Obliged.
Yeah, I have received my instruction, my lord. Okay, allow me to explain to file my affidavit. In fact, it has next instruction, it has come that she is the second wife. During the subsistence of the first marriage, the marriage has
You are the second wife.
second wife.
Expired, Lordship.
All right, Mr. MSS Karthik Bora.
Ajay and Shiva.
File very happy.
This notice was issued on 23/2024, my lord. If it is required, my lord, I can do.
My lord, what I've on a bare perusal of this writ petition, my lord, page 61, the petitioner has already filed an appeal before the chief secretary. He's challenging the order at page 60. He's challenging this order at page 60, and thereafter he has filed an appeal at page 61 before the chief secretary. It is currently pending, and parallelly, this writ petition has also been filed. Lord, may direct the chief secretary to dispose this appeal within a stipulated period of time.
What is that order you are challenging?
Page 60.
60, madam.
Huh?
Page 60, madam.
60.
My lord. Do a file appeal, but there is no any
He's
provision.
seeking-
There is no provision. So, let him file affidavit, my lord.
Provision has been
We'll direct the
Chief
authority to
Secretary,
dispose of the
let him dispose of within 1 month.
if it is pending.
Let it be disposed of. my lord.
Notice was issued by the interim, my lord, even now that can be, my lord.
What if?
There's no point keeping this matter
Pendency, no
pending.
bar
my lord.
to dispose of the appeal.
Huh?
Pendency, no bar to.
No, but if there is a disposal of the appeal, either way, this petition will again, you'll have to file another writ petition.
Let a speaking order be passed by the chief secretary, my lord.
Whether I am entitled or not. That
That
will be decided.
information at the first
Because
instance, if it passed by the department, we have already approved.
No, we have filed well. That was
We
not
can direct
disposed.
them.
That wasn't filed on 1st July 2020.
We can direct them to pass an order, if not already passed,
Within 1 month.
within a time of meeting.
If they are negative manner, again we come to manner, they may manner finally dispose of is whether entitled or not. That's why that.
What to do with the appeal? We have filed the appeal.
My lord, parallelly, 2 forums have been moved. It's better like one forum, let it exhaust its
I am coming before the
jurisdiction
Honorable
within
Court.
1 month. No point in keeping this matters, my lord,
Why
pending.
he has not till today not disposed of? Why he is
Let the
waiting
chief
for
secretary do it.
Well, I am not praying for the disposal of that. They must file affidavit whether I am entitled or not. If not entitled, then decide.
Then what about this appeal then?
If you
That
know
will
that they know that I filed an appeal, till today they did not do anything.
So therefore, we can direct the authority to dispose
My
of the appeal.
instruction is my will decided.
There is no point in keeping 2 fronts open. Let one front be shut once and for all. Let the chief secretary dispose it within 1 month.
Is all right. But decision of the authority, either way,
Already, my lord, they had take decision, my lord, on page 60. So when challenge before lot.
That's why you have filed an appeal at page 61.
I think it would be in your interest to have a direction of the person. If we decide the matter and in the meantime the appeal gets disposed of and something contra is filed, that order will not be interfered with by us.
If instruction is everything is come, that would be everything is come that cannot matter. My prayer is that my lord,
Instructions have not come.
they must file affidavit, they take time, no problem.
There's no point in
What is
keeping these matters pending, my lord,
prayer
unnecessary,
that you
wasting judicial time.
Prayer, my lord, page
What is your prayer?
27, my lord.
You want telephone and security.
My lord, my lord.
That's all.
Yes.
The same issues have been moved in the appeal.
We direct the authority to decide. Direct them to decide. You have filed an exhaustive appeal. I can.
They did not do anything, so they will come before the honorable court. So, my lord, at least, but if we are not entitled, then my lord, finish the matter. So, my lord, let them file affidavit and decide on that.
There's no point dilly-dallying.
Hard. Praying for a direction. Praying for setting aside of the order dated 11 May 2023. Issued by Secretary General. Informing the facilities of telephone and security assistant, attendant officer, retired in the rank of chief secretary and equivalent rank from the government. You were appointed to the post of
State Election Commissioner.
but it has been held to be equivalent to the chairman of the FA, not
And-
the chief secretary.
Well, as chairman is the equivalent to the chief secretary.
It was
At least
informed
that-
that so state election equivalent to the rank of the chairman of the chairman of PSC, also equivalent rank. Thereafter, what, which department?
Panchayat. He was appointed by the PM.
Administration. If this order is passed to the general,
But there is no representative here.
hearing for the response of that there is an appeal already preferred by the chief secretary. I think if it is like that if there is already an appeal filed, the direction of the chief secretary so be it. Pass the order thereof. So, happy with that there is appeal already preferred. Ordinary the report like the exercise rival officers have heard. The revolves around the top cap as to whether internal was appointed as state election commission and right of election is facility available to the chief secretary, the post of chief secretary of the state, as well as post having equivalent. Yes.
I'm appearing for the CAD, my lord. Was on
Any instructions here?
at the moment, also this matter came up on the last occasion, and my lord, I'm still awaiting my instruction. There's a similar matter pending here, my lord. Honorable court. So my lord, may
Appeal is pending, so it is disposed of.
Similar
My
matter
lord,
is fixed, my lord.
Let it be disposed of.
No, my lord,
Easy.
I am not praying, my lord.
Having heard none and
my lord,
in
Let
the
the chief
question
secretary dispose of.
essentially is that the issue raised essentially question of fact and more particular considering that the detailed opinion has been of the to the associate of the chief secretary and thereafter passed the state order indicate whether post of the petition the state election commission is equivalent to that post of chief secretary and that case, and in which case whether the benefit of security and telephone and security is considered is all quite made available when it comes to maybe adequately decided on by calling for the executive court as required. So, any such taking order, the chief secretary thereafter pass taking order, and any such taking order pass for petition. Needless to say, the petitioner will agree that the orders passed by the chief secretary is delivered by the state. The direction be carried out by the appellate authority. Okay. The above submission. We are asking you, we are closing it off because the instructions are not.
My lord,
And these are factually
my lord, one my lord sentence may be added, my lord. So, the additional chief secretary also they have given the my lord page my lord 70. That's why we
submitted by like
also
officers
give
in the rank of
actually my lord as per RTI we have received my lord page 21.
what?
RTI report, my lord, dated.
That's
I'm appearing for 2 and 7.
Mr. Henrik or Henrik had here, but actually for the respective. Yes.
My lord, my condition is only, my lord, I am equivalent to, my lord, chairman of the FPS. And my lord, FPS is equivalent. Okay.
Made cases for lordship, my lord. My lord, here the petitioner retired, my lord, from service 31/7/2020. And thereafter, my lord, his pay, pensionary benefits given pays 41. Now, my lord, thing is that, my lord, after, my lord, upgradation of pay, my lord, his difference amount, after upgradation of his pay, my lord, from 29/10/1988, my lord, has not been paid. Initially, there was inquiry against him, my lord. That period was, my lord, regularized.
Yes, who was the respondent here?
Last occasion also there is a direction to show the names.
Who is for the respondent?
The names have been shown.
Tribal affairs.
Lordship, we are for respondent number 1 and 2, social justice.
What do you have?
Lordship, there is no instructions right now.
So what is your prayer?
Lordship, 3 weeks time to seek the instructions.
3 weeks. Give you 2 weeks.
Man.
Third, what's your name?
Miss A. Lodha.
A. Lodha.
Correspondent. 3.
3. For 4. SD
Look, Mr. Dhar earlier appeared, man.
SDW. What is that? Welfare officer.
Yes.
Ian. Mr. Surya for after
Oblige your Lordship.
May I have Lordship? Lordship, in this case, Lordship, petitioner is the second wife. First wife got pension, she died. Second wife is claiming for pension, Lordship. And Lordship is in a similar matter, Lordship.
second wife got pension. The first wife got pension after family pension.
Family pension, Lordship. And
died.
she died, Lordship. And now the second wife is claiming for pension as per.
How is the marriage recorded?
Yes, Lord. The page, Lordship, 11 is the Lordship succession certificate. Lord.
But what was the marriage? What way? How's the marriage happened?
Page 11, Lord.
11.
Lord. Character 1 is the succession certificate, Lordship, which was the Lordship obtained, Lordship.
11 is not the success.
Succession certificate. Page 11.
Succession.
Lordship. Issued by, it is Lordship issued by district judge for Petala. And first wife is Jahura Khatun. And second Lordship, Mahila Khatun. She is the petitioner. Yes. And Lordship, page 13 is the Lordship legal year certificate, Lordship. It is issued by the Deputy Commissioner, Barpeta, Lordship. Here also, Lordship, entire family is there, Lord.
Who is the petitioner here?
Here is the Lordship Mahila Khatun. Yes.
Now,
Lordship, after the death of the first wife, Lordship petitioner submitted application, Lordship, and our application was forwarded by the Lordship Executive Engineer, Lordship, page 23, Lordship, to the Accountant General, page 23, Lordship. Was forwarded on 1/6/2022, Lordship. After Lordship, nothing has been done, Lordship. Lordship, the similar matter, Lordship, this honorable court has disposed of this matter.
Similar matter will come later on because it is a pension matter. Everything is to be seen, Miller. Because yes,
let us see that similar.
I also do not know what similar.
You have a look and tell us how similar it is.
Because then
Similar or dissimilar.
no, forget that.
Yes, yes,
I did it. I did it. Okay, did it. But each case is no doubt in that. Covering some judgment.
Page, Lordship, 11, Lordship. Sorry, paragraph 11, Lordship.
Yes.
Everything is similar, Lord.
No.
She was Lordship, second wife, first wife, Lordship.
Here, Miller.
Paragraph
No, I have gone through. I have to know. Here, the cases, Miller, generally pension cases, what happened, this principle will govern, definitely. But we have to receive the papers in correct shape and complete manner. Until unless we get, we cannot do so. We now, my humble prayer before Lordship.
From whom? From the department.
Yes, from department. Here, Miller, today's my submission is very limited, Miller. Yesterday, because this is the second day, due to my communication also a little bit got delayed, I may be allowed 2 weeks time. I'll clear everything because why it has been, because 22 meters, why it has been not sanctioned. I'm also on doubt. That is why my yesterday office has asked me, requested me to pray for Lordship 2 weeks time. Maybe listed 2 weeks, if it is within this period, if it is she's entitled, we will pay also about it. But 2 weeks may be granted to enable me to file.
For you, the department has to be.
The department, according to them, department has sent it. That is why, according to his application, Lordship, page 23, I'm not denying on that, my lord. Page 23, Executive Engineer has sent to Accountant General. That means ball is it has.
So why 2 weeks? It is short day.
No, Millard, why? Because here it is the problem. We deal with some department. That particular section, something 2 weeks only I'm paying, Millard. The second day only. 2 weeks, Millard.
At 8, maybe 6 1. Let me fix. Still 67 years.
Paying, however, that's one number 3, Millard.
Raise for further time. The matter. 27.
Millard. 27 may not be because 28 my data states even.
27,
27 because 27 I'll be out. Maybe on
27th of May.
That is I'm telling Millard. That is I'm telling. That is 28 May my is here. First week or 2 or 3 Millard. Or it may be before that. Before that. 24 Millard.
20.
Oh, 20. Yes. 20 May. 20.
Yes.
My lord, I have just received an instruction. Instruction is that, my lord, local public and the SMCS denied to take over SAS and that BO has cancelled his order.
BO has cancelled?
Yes.
Your order is cancelled. Your order is cancelled. You have a look. Cancel. So you have to challenge it.
This order is passed today itself, Lordship.
Yes. So what to do here? We are closing it, giving you liberty to file.
Lordship, Lordship, then if Lordship order is cancelled, where the petitioner will go now?
That I don't know. But if you are aggrieved, you have to challenge it.
Lordship,
And so far as this order, this writ petition is concerned, in view of this order, it has become infractor.
that is what they have done.
You think about it, we'll take it up on Friday. List on Friday.
Friday, Lordship.
Or we are closing it today. What is the point?
Lordship, close.
Huh? Close it. I heard Learned Counsel writ petition was filed by the petitioner, praying for direction to the respondents. Allow the petitioner to join in Alipuri ME School as headmaster in charge in terms of the order dated 2/4/2024, issued by the PEO, Lahori Ghat. The respondents were permitted to obtain instructions. They submitted.
Lordship, here only the handing over and taking over charge of head teacher has been cancelled, Lordship. And the disease order is still remain, Lordship, revert back order.
That is what you want. You wanted to be reverted as a head teacher. Otherwise, you go and join as an assistant teacher. There is no problem there.
Lordship, I will challenge.
Submits that by order dated 24/4/2024, the block education, elementary education officer has cancelled the order earlier issued. The present head teacher in charge, MD Akhtarul Haq, MD, respondent number 5, to hand over charge to the petitioner. However, because of the objections raised by the school management committee as well as the local public, the order of the district elementary, order of the block elementary education officer has been cancelled. Order of the block elementary officer to hand over and take over charges of the head teacher, so far as the writ petition is concerned, has been cancelled. As such, in view of the order passed today, that is 24/4/2024, the order dated 4/2024, the benefit of which petitioner had claimed the present writ petition, having been cancelled, the writ petition has become invalid. The same then dismissed with liberty granted to the petitioner.
Yes.
Approach his court if her grievance of this block. Needless to say, since the order that is cancelled is the order directing the respondent 5 to hand over charge as the head teacher to the petition. But the order of the order of reversion of the petitioner, his original post of posting remain, and the petitioner should be permitted to join his original place of posting is going. the above the matter. So in view of the above, then this is Mr. Pegu and Mr. Malikia. Thank you. Yes.
That matter, sorry. In that matter, my lord, that releasing from sector officer by the district election officer. That has been challenged here because on the connected requisitions are there, the transfer order was stayed. I have challenged this on the ground of that Melafide, what has occurred, because on 3 occasions they were not released from the service, the sector officer service. Now, as soon as we have obtained the stay order from this or status quo order from this honorable court, within 3 days the release order has been passed on 19/3/24. Then that has been brought into notice of this honorable court. Then status quo order was continued. Then later on 29/3/24, Annexure 18, Annexure 13, page 88. Annexure 13, page 88. My lord, that releasing order was withheld. Then subsequently the matter was taken up on 4/4/24. They have obtained leave of this honorable court. That is, your lordship will find 8 page 90.
Yes.
Yes, my lord. Down below, my lord, Mr. Ali so-and-so election commissioner will submit that as the petitioner has been proceeding for a very long period of time and the ESI is apprehensive that fair and smooth conduct of election may not be possible if the petitioner is continued to be appointed as sector officer or magistrate and so and so and so and so. So seeks leave of this court to pass an appropriate order relieving the petition. So on the next day we have been relieved. So that is challenge here. General, what has occasioned them? On 3 occasions they did not do. On 1/1/24 we have been appointed as sector officer. Then on 29/2/24 we have been sector officer.
What has been stayed by this order? 4/4?
4/4, that matter they have been given the leave. Passed to appropriate order.
There is some interim order. Notification dated.
Yes, interim order. That is a transfer order was stayed.
Transfer.
Yeah, transfer order.
Ah.
It is subsidiary side by side, my lord.
Where is the transfer order?
Yes, transfer order you will also find Annexure 3, page 19, 34. This is my lord, pursuant to election commission guidelines, and officers who have been working in the home district and who has completed more than 3 years of service, they have been transferred.
So that is state.
Yes, that is state in respect of the petitioner to only.
Okay.
So now on 5/4, after taking leave, they have passed this release order, this interim order that we have telling them.
But they have been given leave.
Yes, sir. Taking leave of this honorable court.
Given leave by the court.
Yes, the leave.
Then?
They have taken leave, my lord. To, but just my challenge is that, my lord, on all occasions. I mean, on first occasion,
No, the court has granted leave.
Leave to pass an appropriate order.
No, appropriate order to relieve. You as the second.
No, he has prayed for that they will pass order to release the order. Then court has granted the leave if so advised, my lord.
Correct.
If so advised, there is not that mandamus that you release them.
No, certainly not. But there is a leave. If they want
Leave,
to
yes,
grant-
leave has been granted. Yeah, that is my. This leave has this releasing the petitioner from this duties, my lord. It has been occasion from.
Where is your legal right that is you cannot be relieved from this leave?
No, I have no legal right now.
Then?
But now, what has happened in this case is that on 15/3/23, 15/3/23, they have appointed me again for third revision as a sector officer, my lord, on 15/3/23. On 15/3/23, this honorable court has passed the status quo order, man. The matter was listed for 21/3/24, my lord, 21 March. On 19/3/23, 19/3/24, on after 3 days, my lord, of passing of the status quo, because we have obtained the stay order, my lord, from this honorable court. So it has, my lord,
prompted him, the respondent number 2, to pass and release order. Something is there, my lord, policy act is there to the department. So there is a complete malafide, my lord. Because others on this ground,
Malafide against whom?
Against the respondent number 2. Respondent number 2. What is, because on 3 occasions from 1/1/24, then 29 to 24, then 15/3/24, on 3 occasions, he did not have that, my lord.
Current council for the parties issue notice.
Yes, madam.
Since respondent who has been narrated as the party, notice be issued by registered post with the neutral court, Mr. A. Ali, planning council.
That's one number 1.
Yes, respondent number 1. Since Mr. Ali appears, no, notice the waive, however, extra copy need to be one thing. List after return.
All right. Any interim, my lord?
Sorry?
Any interim, my lord?
No, no.
What?
Election is on 26th, Your Honor. Polling, it is on polling day is on 26th, Your Honor. At least
What interim to be?
But then, my lord, or interim order will be considered next day.
This is passed pursuant to leave.
Yes, sir. Okay,
by the board.
Then just one thing is that this matter will be listed along with WBC number 1525/24.
Those maybe this is listed independently. Your Honor.
This is on a different ground. How is it?
Because they have not made part and party, Your Honor, in this case.
Isn't it? That is where
But it is connected to the transfer.
It is connected because it pertains to the same person.
Yes, same person. Okay, that's all right, my lord.
But your grounds are different.
Yeah, ground. Of course, cause of action is different.
Cause of action is different.
Oblige. Oblige.
Made legal option. This petitioner, they are, my lord, working as a, my lord, employees of the sugar mill, my lord, because closed down in the year 1997.
Yes.
The earlier writ petition, my lord, in the writ petition filed by in the Honorable Court by the employees of the, my lord, sugar mill, my lord, and that writ petition, my lord, they are mark, my lord, 855, my lord, employees, my lord, they are entitled to get closure benefit and VRS. So this amount has been sanctioned by the government, my lord, and already it is in the hand of official liquidator, my lord. And earlier, my lord, in writ petition, there is some direction issued, my lord.
Where is that direction?
Direction, my lord, page. Your lordship will find page 43, my lord. Page 43, my lord. Relevant portion is, my lord. (49), my lord. Your lordship kindly wants to look to the para 17 of the page 49, my lord. Page 49 has your lordship. Page 49, para 17. It is as well. May I read it, my lord? On 7/6/2010, official liquidator of the sugar mill was present before the court, and along with the registered cooperative societies, and has present in the complete list of workers and employees entitled to receive the voluntary retirement dues on 13/8/2010. The court noted that an extensive process of verification and calculation has to be completed for 855 workers and employees of the sugar mill entitled to VRS. It was noted that the pending completion of the verification exercise of payment of so-and-so, he was paid to the 211 employees, 149 payment 64 seasonal workers. It was also noted that the additional 211 employees who have approximately 2,000 other employees were identified were established. The court is directed that payment will be next extended to 50% of due to the said approximately 200 identified employees should be made. Direction was issued in completion of verification process to finally the disbursement of VRS within 3 months. Now, my lord, that was my finding in present, my lord. Official liquidator and registered cooperative society also present. And
no, what was the direction?
Now, direction your lordship will find, my lord. Page 56, my lord.
56. Yes.
para 29, having noticed the board pressure of the claim and the employees and the worker with various grade and actually update that litigation has taken place during its long pendency of this court. The court is of the view that instead of keeping the matter pending any further, it will be the just and proper to wind up the proceeding by issuing the necessary direction. Accordingly, the following directions are issued. Number one.
So you were directed to file before the official liquidator.
We file, my lord. File, and these are the documents they have to verify and they have to say, my lord.
And what was
Now they turn up. They turn our debt.
what is the order of the official liquidator?
My lord.
Where is the order of the official liquidator?
Yes, that is my lord. Your lordship will find, my lord. We start from, my lord, page 62. My lord, order is 61, 63, my lord, sorry. Scale number, that B, my lord, clause B. The petition actually have been paid an amount of rupees 2,200. My lord, can it be a, my lord, closure benefit and VRS is 2,200, my lord? So that's why, my lord, I'm challenging this order before this honorable court. Yes, we are casual employee and seasonal employee. We are getting, when we are working, we are getting salary, and when we are not working, we are getting the retainership, my lord. So that was the contention of the respondent in the earlier petition, my lord. Now, my lord, there as a result, my lord, they have, that is calculated by whom? It is calculated by one of the CA, my lord. When CA calculated, but what about our provident fund, my lord?
No, but
no, that's why, my lord, your lordship kindly see very interestingly in our petition there, para 17 and 18 is my case, my lord. Your lordship kindly see. Para 17, my lord, page 38.
Yes.
Para 70. The petitioner begs to state that the order that is 22/9/2016 Annexure C to Annexure 1 to 142 is bad in law on the following ground. The official liquidator did not consider the claim of the petitioner as per direction of the Honorable Court dated so and so, passed in WPC number so and so. The petitioner are entitled to VRS closure benefit as employee of the sugar mill, but the official liquidator did not consider the same properly for the name. Although name of the petitioner are included in the list of 855 employees, the sugar mill, who are entitled to VRS and closure benefit. The money which was sanctioned by the government as a closure benefit for the employee of the sugar mill still lying in the bank, but the official liquidator most perfunctorily issued the order that is without considering the respect of the matter. The official liquidator did not at all consider the relevant documents and recorded his issuing the impugn order that is so. Their total non-application of the official liquidator to the impugn order that so there is no discussion about the closure benefit, VRS, other benefit, including the contributory provision one, which the petitioners are entitled. The official liquidator, while passing the impugn order dated so and so, did not all discuss and did not give any finding on the entitlement of the petitioner in respect of the closure benefit. Next, my lord, para 18. This para 17 and 18 is very important, my lord. I am submitting that para 18 that the petitioner begs to state that under the facts and circumstances as stated above, and for the end of justice, the Honorable Court may be directed to the respondent or to produce the following relevant document. Total amount of sanction by the government for the employees of the sugar mill and closure benefit and VRS. The details of the amount already paid to the official liquidator to the employees of the sugar mill as closure benefit and VRS. The detailed bank account statement and respect of the money sanctioned by the government to the sugar mill closure benefit. Detail about the employees who have been paid VRS closure benefit. So these, my lord, are the documents they have to, my lord, ask to produce, my lord. I paid, my lord, but they have not answered this, my lord, these two para, my lord, properly. So that is our case, my lord. Well, can it be, my lord, we are working for more than 10 to 12 years.
What about the other direction? One, there are in page number 56.
My lord.
There are 3 directions to the official liquidator.
My lord.
Then there is a direction to the Regional Provident Fund Commission.
My lord, there is no answer, my lord, till now, my lord.
No.
They are discussing my entitlement. They said that, my lord, you are always a casual employee, so you are getting only entitled to get 1 month salary, that is 2,200. So can it be how they calculated it, my lord?
We want to understand what is the meaning of the direction at serial number 4 onward.
The Regional Provident Fund Commissioner Guwahati self-forwarded a resolution of the government of Assam in Cooperation Department within demand to release the balance amount of due to the employees and yes.
Is this subject to a decision given by the official liquidator?
My lord.
Or this is independent?
My lord, actually it is Provident Fund Officer Commissioner is independent, my lord.
So it appears to be an independent direction
My
of the
lord.
court. This is not dependent on the findings of the OL.
Oh, yeah, correct, absolutely correct, my lord.
So who's for the Regional Provident Fund Commission?
I represent the Cooperation Department.
No, my lord, everything has to be, my lord, official liquidator has to communicate it, my lord. Because what are the provident fund amount, my lord, deducted from the salaries of the employees? That list has to be, my lord, placed before the authority, my lord. So that's why, my lord, record is very much necessary in this case, my lord. So they were asked to produce that record, my lord. Because at the list which was prepared by the official liquidator at the time of, my lord, earlier hearing of the earlier petition, my lord, 855 employees, they are entitled to get closure benefit and VRS. We are included in that 855.
Provident Fund is not even made a party here.
Well, Provident Fund is not a made party, but we directly, but until and unless they produce the list, these are the amount we are deducted and placed there before the authority. So that liquidator has to take a call, my lord. Official liquidator has to place the, my lord, that list.
Official liquidator is also struck off as a party.
No, my lord. Official liquidator, my lord. No, that is managing director, my lord.
Huh? Respondent for who's respondent?
Managing director of the Assam Cooperative Sugar Mill. There is no cooperative sugar mill right now. The managing director.
Anything that. Who's for the official liquidator?
Official liquidator, lordship, I can appear.
Huh?
I can appear, your lord.
You
Because
can appear.
He's an employee of the Cooperation Department.
See, if you look into the order at page 56, there is a slew of direction.
Lordship.
At least, how many? 7 directions?
Lordship, there are 7 directions.
Not 7.
No, 10 directions.
10 directions.
10 directions. Now, how these directions have been complied with? So far as official liquidator is concerned, it is direction 1, 2, and 3.
Lordship.
Then,
Also, after passing of the order, the annexer C2 that has been passed by the order has been passed by the official liquidator.
kindly read the directions again.
My lord. Serial number 1. The employees and worker of the sugar mill having any
No, you can skip 1, 2, and 3.
My lord. 4. Regional Provident Fund Commissioner Guwahati self-forwarded requisition of the government of Assam in Cooperation Department within 30/12/2015 for release of the balance amount of rupees so due to the employees on account of employees' share of the Provident Fund. On receipt of the such requisition, Cooperation Department shall do the needful and obtain budgetary sanction for the said amount and any other additional amount that may be worked out in the meanwhile to meet for the full and complete VRS due to all the employees and workers of the sugar mill. Finance Department, Government of Assam shall extend the necessary cooperation of the Cooperative Department and approve the due amount. It is the executed that expected that such amounts shall be made available within the official liquidator with a period of 4 months from today, from 31/12/2015. Regional Provision Fund Commissioner shall depute and authorize a complete officer to assist the official liquidator while deciding an individual claim. Two authorities shall arrange joint sitting as and when considering necessary. the sustained attachment order of Regional Provident Fund Commissioner Tinsukia on the bank account of maintained in the State Bank of India, Dergaon branch shall be lifted after 31/12/2015 to enable the disbursement of the official liquidity to the verified and identified employees and workers of the sugar mill. The Secretary of the Government of Assam Corporation Department shall nominate, monitor the steps taken by the official liquidator. The entitlement with claim shall be verified, and wherever the amount is found due shall be released. Individual orders shall be passed by the official liquidator on each claim petition. This exercise shall be completed by 31/7/2016. 10. In the event of any of the claims still neutered events, it will be open such claimant to avail the opportunity remedy on may be avoided under this law. Needless to say that if any of the employees of the workers have expired, and meanwhile that legal hire will be the entitled for issue of the same. So, my lord, your lordship kindly see how they rejected my my lord, how they calculated, my lord.
What are the claims? What are your claims?
My claim is that, my lord, we are the employees of this, my lord, that sugar mill, my lord, that closure benefit, my lord, sanctioned by the government, my lord, this is closed down. The closure benefit, my lord, while they are distributing the closure benefit, my lord, that, my lord, whatever the chartered accountant says, my lord, that amount has been paid. Without considering this whole document, my
Now,
lord.
what is the direction at serial number 4?
My lord.
Serial 4?
Serial number 4. The Regional Provident Fund Commissioner Guwahati shall forward a requisition of the government to Assam the Corporation Department within for release of the balance amount of the employees account of employees share of the Provident Fund. That is employees share of the Providence Fund. That has to be. Probably that has been released.
Has it been released?
No, that is no, there is no minor order regarding.
Have you filed your counters?
Yes, Your Lordship.
What have you stated there?
Lordship, the on basic stand is that the petitioners are casual workers, Your Lordship. And that's why they have been paid rupees 2,200 on liquidation, Your Lordship.
On what basis?
Lordship, because they have been, at the time when they're working, they have been paid on a daily wage, Your Lordship. They have already been paid. And later on, I have also filed one additional affidavit, Your Lordship. That will be serial number 204. Now, in that additional affidavit, I have stated that as on date, there are around rupees 13 lakhs that is available with the SBI Dergaon branch. That is the unclaimed amount of the untraced employees, Your Lordship.
How many untraced employees are there?
Lordship, that specific instruction I don't have, but
what
as on date, there are 13 lakhs that is lying in the bank account.
And how much amount have you disbursed?
Total around 21 crores, 21.86, Lordship.
Where have you stated all that?
Also, I have stated in page number 206, Your Lordship, paragraph 4 in my additional affidavit.
Additional affidavit.
Yes, Your Lordship. Paragraph 4, Your Lordship.
You have not disclosed any amount.
Lordship, it is
Details of amount.
Yes, details has not been disclosed.
As enclosure. Where are they?
In that case, Your Lordship, I have to get the record, Your Lordship.
You are seeking a direction from the court to produce the relevant record. There at page here. Now 17. Earlier it was 206.
20.
How many employees are there?
No, my lord, actually, who are entitled for VRS and closure benefit, my lord, 855 employees, my lord, identified. So that is the earlier judgment is clearly reflected, and against them, my lord, government has sanctioned the amount. My lord, not only my lord, they are due, so there is a lump sum for closure benefit. This is closed down, so we'll get lump.
You show us how the calculation
Has been made, my lord. That was the case, my lord.
In that case, I'll get the recording. That will be lodged.
Any, but
my lord,
we are just trying to examine whether this official has of your cases or that.
My lord, my lord.
But assuming it is disposed of, then the correctness of the order, whether we will be competent to examine it, case of matter.
No, at least, my lord, how they calculated it. That's why, my lord, details. In the similarly situated, my lord, some they have given those who are, my lord, blue-eyed boy, they have given, my lord, lakhs of rupees. But these.
It hurts. Closure benefit.
Closure benefit.
What is that? What is it? What is that mean?
My lord, Assam Cooperative Sugar Mill, my lord.
Assam Cooperative Sugar Mill at Dergaon.
Assam Cooperative Sugar Mill, Dergaon. Pura Mamungaon, Dergaon.
Earlier, you had approached the court by filing the WPC number. What was the earlier requisition number?
Earlier requisition number, my lord, WPC
1930.
2008, 1930, 2008.
This petition was referred by the association of the workers, along with some other individual, another individual.
My lord.
Both these petitions by order dated February 11, 2023 by the following direction. Page number 56, direction 1, 7, 8, 9, 10. Pursuant to this, that individual orders came to be passed by the official. Copy of such order is sorry. What about the other requisition 5886?
That is, my lord, similarly situated, my lord. Same direction was issued, my lord.
Copy of one such order available, and I think that's C2, page 65. It's submitted by the government that is petition that the claims of the petitioners were disposed of by the official regulator, but without adhering to the direction by the coordinate bench by the order dated. By the said impugned order, an amount of rupees 2,000 was found to be payable, and the same was paid to the petitioner, and their claims were disposed that such decision of the official regulator is without any basis, and how the calculation has been arrived at is not discernible from the council appearing of society has referred to an additional aspect by court submit that the total amount of fees 2618.85 lakhs has been disbursed as employees liability and state organization. And these amounts were disbursed from a verification of that apart an amount of rupees 13,48,863 is lying at the SBI Dergaon branch. This is lying in the account of the society. Account of the SBI Dergaon branch, account of the society within bracket under liquidation. Of this amount is in respect of the dues of the ungraced employees of the liquidated sugar mill. So, it is submitted that the disbursement as found due has been released. All the employees, including the present. Mr. Portlo, however, is unable to submit as to how the calculations have been arrived at, as the same is not elaborated affidavit. So, the orders passed based on the individual petitioners are also do not reflect the manner in how calculations have been arrived. Under such circumstances, it is directed that the relevant reports pertaining to the case as to how the calculations have been arrived at in respect of the writ petitioners at least be placed before the court. And the respondent are required to justify that the same has been disposed of in terms of direction contained in the order dated so and so passed. In the earlier order dated so and so passed by court and with the records as directed be produced, relevant records produced before the court by the date they fixed. And we fixed it again on 4th of May. Sorry, 4th of June.
Keep them. How like it?
4th of
In this case, the records have arrived, Your Lordship. But Mr. Dean was supposed to address the court here, but he's on Lexington court number 1, Your Lordship. Can it be on Friday or Monday, any day, Your Lordship? So Thursday, he has some difficulty. Let it be on Friday.
Friday.
No, they have difficulty. Right.
Let the matter be held on Friday as briefed by the counsel against the bar. Records for the date. Right.
Publish. Interim continues till Friday.
Interim order passed. Right. Yes.
Lordship, the petitioner counsel has served us the extra copies just some time back, Lordship.
Yes, you are submitting that this matter is then covered by the order.
My lord, may I just submit here one? My lord, the item number 63 of today's list, my lord. We have filed a review petition, my lord. So, my lord, that may be taken up first. Because what has happened is, my lord, in our review petition, we have got nothing, we are not interfering, we are just asking your lordships interfere.
Sorry. Well, in this case, my lord, I could not start the copy earlier, ma'am. Today I have start copy to all the parties, my lord. And the main respondent, my lord, counsel for the main respondent states that his copy has been sent to office, my lord. So, may I come, it may be listed after a week, my lord.
Yes, yes. He's prayed for some order file. What review?
My lord, my review petition is item number 63, my lord. So what has happened is, my lord, at page, if my lord has got to the file, my lord.
I have no knowledge about this.
Yeah, because the notice has to be issued.
Oh.
It's a similar matter because it's a continuing of the episode.
Yes.
So, my lord, at page number 37, my lord, on 5/1/2024, page number 37, my lord.
Paragraph number?
My lord, page 37, the second paragraph, my lord. Accordingly, a meeting of the Joint Consultative Committee between the State of Assam, APDCL, APGCL and AGCL are being conveyed very shortly, and a concrete decision will be taken therein. My lord, this was on 15/5/1/2024, and accordingly, the matter was listed on 15/2/2024. And then thereafter, my lord, on 15/2/2024, my lord, at page number 41, Mr. KP Pathak, learned counsel for the respondent, so and so, prays for further time to complete the instruction. He submits that the meeting of the joint
You are
consult.
referring to the order on the review.
Yes, my lord.
Oh, where is the error apparent?
My lord, there is no error as such, but this order, my lord, what has happened is that the order which the Joint Consultative Committee meeting, the contents of it, has not been reflected in the order. Because of that, my lord, there is some hurdle. Because the Joint Consultative Committee meeting was the only base on which the entire purpose has to be served upon. This has not, page number 42, my lord, annexure F, has not been reflected in the main order.
It was not placed on that day, my lord. How can it be reflected?
My lord, it was only this context.
This order was passed on the basis of the earlier order passed in WPC 1607.
Yes, my lord. But after that, my lord, because other cases were APGCL's cases, my lord. It was not APDCL that has come into it. So when the APDCL come to it, we had directed a joint consultative meeting to be happen. And there is nothing we are not taking away the benefits of the employer or something. It is only the last paragraph of the prospectus of payment, my lord. Only on that aspect. My lord may see, my lord, that thing has been there on the order of all the orders, but on the day, my lord, the order had been passed. Somehow this, it has been left out, my lord. My lord, what has happened? My lord, on the order, Annexure G, page 43 is the order, my lord. My lord's order. My lord, in this order, the joint consultative meeting reflects the discussion or the point of consideration of the joint consultative meeting with regard to the case of the petitioner has not been taken into consideration. And my lord, this is very much essential for us, my lord. In the final order, my lord.
How does it affect?
It affects us, my lord, because there is a huge financial burden upon us. So that is why what we had did, that we have said that we will be paying the benefits within them, but there's a time period that has been mentioned that we will pay 2 months of such applications and the area within 2 financial years. My lord, if this gets reflected, nothing else is there, my lord. We are agreeing with the judgment of lordship, only this part of Annexure F, page 42, that if on receiving the application undertaking from the respective pensioners, the revised monthly pension will be paid within 2 months of such application. However, area benefit will be paid within 5 installments in the span of 2 financial years. My lord, the APDCL is on a huge financial burden. And my lord, on that interest.
We are disposing this writ petition.
Yes, my lord.
Relying on the judgment rendered by coordinate bench.
Yes, my lord.
Against which there is an appeal.
Yes, my lord.
Therefore, there was the direction that if even undertaking in case of any adverse order, he refund.
Yes, my lord. My lord, what has happened is that when the first writ petition was filed, it was against the APGCL, not APDCL. So when this petition, which has been where my lord's order has been done, it was against APDCL. So when it was against APDCL, my lord, before the last order, on the last occasions before that, my lord, we had apprised the court that there is a joint consultative meeting that's been happening, and the result of it will be very much essential for our financial burden. That is the only ground. Even though there was a judgment, the joint consultative meeting was there. My lord, that has been reflected on the orders previous to the my lord's final order. So that meeting happened on 27/2/2024. However, even though this was so that reflection is not there.
Who appeared for
It was not,
APDCL?
my lord, it was not placed before your lordship, my lord.
Who appeared for APDCL?
APDCL, I appeared, man.
So in this matter, 7/3/2024.
7/3?
No, sorry.
7/3/92.
This is the order you are seeking review.
Yes, my lord.
7/3/2024.
Yes, 7/3/2024. So my lord, here, my lord, for APDCL, my lord, the person who appeared, he somehow did not give this order. Well, that is why we are reviewing. My lord, it's only till that extent that the 2 months of application, that aspect, even it was placed, my lord, this has not been taken into consideration.
What application?
My lord, annexure page 42, my lord.
40.
Yes, my lord. That on receiving of applications and undertaking from the respective pensioners, the revised monthly pension will be paid within 2 months of such application. However, area benefits will be paid in 5 installments in a span of 2 financial years. But this was the entire.
Then what was the direction of the court?
My lord, the court somehow, my lord, it's been mistaken on our part only. But this, nothing of the joint consultative meeting has been recorded there, my lord.
So there is no direction that it has to be paid within 30 days, 40 days, 50 days, like that.
Absolutely, my lord. But this is very much necessity to be part of it, because only on this pretext, my lord, on the other 2 dates prior to that, we have been appraising the court that this joint consultative committee be happening, and we are not shying away or taking away the benefit.
How does it make a difference?
My lord, it makes a big difference because of the last line, my lord, that area benefits will be paid within 5 installments in the span of 2 financial years. My lord, it is a financial burden that we are facing. My lord, we are agreeing with the conditions of what my lord.
See, in the order passed in this court by this court,
Yes, my lord.
direction that it has to be paid within any particular time. Nothing.
My lord, yes, my lord, but there has been said that I have also pursued the order dated so and so and find no stay in view of the writ petitions holding the petitions covered and therefore extend the benefit revised on the ROP 2017. So the terms of payment may be, my lord, may be laid down as per the joint consultative meeting. That is what we are saying.
Not a ground for review. Why is it a ground for review?
Because, my lord, this is the only aspect.
You pay by whatever term you want. Where is the bar? Where is the restriction?
My lord, the restriction would, my lord, if this is not part of the record, my lord, tomorrow while we'll be filing there will be a writ appeal which the writ is pending. If this doesn't come on record, we'll be affected by it. My lord, that is why we are just saying that, however, area benefit, only this line.
You place it before the appellate court. That this
My lord, may then give me some. My lord, may give me a time. Let the additional AG apprise this court with regard to it, my lord.
Well, apprise the court
With this, because of the essential, because of the financial burden, my lord. Because I know there is no time.
The council, why making submissions irrelevant? Is there a see? You have admitted the financial burden.
Yes, my lord.
You are not denying that this amount to be paid.
Yes,
Your
my lord.
only grievance is that it has to be paid over 2 financial years or 3 financial years.
Yes, my lord.
This order which was had disposed of is did not lay down any time limit.
Absolutely, my lord. Absolutely, but my lord, there is, my lord. I'll just rephrase what I'm saying. My lord, entire episode is only with the APDCL, not the other 2. With the APDCL, what has happened? It was with the joint consultative meeting. The entire effort or the meeting of the JCC.
The joint consultative committee.
Yes, my lord.
Comprises of how many members?
My lord, 5 members, including the APGCL and APDCL.
Exactly.
Yes.
Whatever decision is taken by the joint committee.
Yes, my lord.
It will be equally applicable to them also. Would it not?
Yes, my lord, it will be. But it will be. Now what has happened is, my lord, because my lord may see, there are more than, there are lots of petitioners there that will come up. So, my lord, if this order gets reflected, the contents of the joint.
It is not a case for review. That's what we're trying to make you understand. Where is the error on the face of the record?
The error as such.
Error would have been that we had the direction contrary to the decision which had already been taken place. It was placed before the court, and somehow by oversight or by mistake, it was not brought before the court. It was oblivious.
My lord.
There is no specific direction in time limit. You are required to pay.
No, my lord.
Admitted that yes, you are required to pay.
No, my lord may at this junction, I just want to at the end.
We are not here to take decisions on behalf of the corporate. You have taken a decision, implement it.
No, my lord, that is what we have to implement. But this entire aspect, if it gets clubbed with the order, because this happened.
That's what we're trying to understand. How does it benefit you, and how does it cause a problem for you if it doesn't get?
Because if this does not,
a part of.
Because if it does not get implemented, my lord, this does not get implemented, tomorrow there will be consequences that the entire money which has been let out, they would come and say that you have to furnish the
What
direction.
is the direction? That
No,
you have to
the
take
direction is, my lord, the direction is such that, my lord, if my lord has said that, therefore he may be extended the benefit of the revised law 2017.
That's right.
So, my lord, that those extra lines that as per this,
Why should we? Why should we? Why should we reopen a matter which is already closed? You want some extra line, go to efficient, get answered. Why by way of a review?
my lord, I would just request my lord just to fix it on Friday.
No.
Let the additional, my,
These three matters you wanted next week. Fine. Three matters, item number 43, 44. How many? Two matters.
Two matters, two matters.
Two matters. It is listed.
There is a third of May, 3rd of May.
3rd of May.
Fine.
Monday. Listed on 3rd of May. All right.
Apply.
my lord, with regard to item number 63.
No, sorry. 3rd of May will be next Friday. Yes, 3rd of May. Item 63 dismissed.
My lord, may it fix on Friday, my lord, let the additional AG
Let
apply.
it be on 3rd of May. All right.
3rd of May, my lord.
We find no ground for it.
My lord, it's only with the 131 employees that we are concerned with, because tomorrow they would come and file a contempt against us that we have not.
How?
But
Where is
because,
the direction to pay it within 2 months?
absolutely, what has fallen from the absolutely, but this, it was only on the basis of the joint consultative meeting that we have been.
Whatever it is, joint consultative committee meeting has not taken a decision not to pay.
Yes, it has taken a decision to pay.
And we have directed you to pay.
Yes.
So where is the conflict?
But, it's only because if it would have been reflected in the order that it will be more, it will be more possible for the authorities to.
We are restraining ourselves from passing strictures against the corporation because the corporation is trying to put words in the order of a court. You want the order in a manner that you feel could be beneficial to you. No, sorry, that is not permissible.
No, my lord, it is.
You are agreed to go in a peace.
No, my
We are
lord.
not here to look after the comforts of the corporation as to how the orders should be out so that they can very comfortably.
No, my lord, it is.
Keep rubbing their fingers and their hands in glee.
My lord, I would apprise it on 3rd of May by taking some aspect.
Dismiss with cause if you don't withdraw.
On 3rd of May, my lord, may fix.
Dismiss on 3rd of May. We have already explained. This is not a ground for review at all. Review. What are the parameters for review?
Error apparent face of the record also. My lord, I absolutely understand what's falling from my lord.
Stopping you. Go in a.
My lord, there is.
Argue whatever you want to argue. Unless there is an error, what is the ground for review?
It's only with regard to all the orders were passed earlier before that. Had the matter mentioned joint consultation. My lord?
Do we dismiss it today?
No, on 3rd of May.
On 3rd of. On 3rd. Yes.
And in this matter, respondent number 1 file an affidavit, my lord. I have to file a reply, my lord.
Sir, NNB Chaudhary, Joint Counsel. Okay. Sir, an affidavit has been filed by the resort of
One.
It is like item 5. Prayer made is not objected by the. Yes, sir. 3 weeks.
That's my 3 weeks. That may be given, my possible.
The day appears for
the following investigation, number 7 and 8.
List after 3.
May I get a copy of the affidavit?
No, respondent number 1 file.
No, he wants to file. Once he files, he will definitely give you.
My lord, only thing date may be better. Other than matter of date may be given.
Date may be. It's on 27th of May.
Yes, ma'am.
27th.
Can it be, my lord, 29, my lord?
29th.
Yes, ma'am.
29th of
20, no, sorry, my lord. 29, I am not available, my 30 May, my lord. 30 May.
You give us your calendar, we fix a date as per your.
30 May, last.
Not 30.
Yes, ma'am.
You have it on Independence Day.
Yes, ma'am.
Or we'll have it on 31st.
Yes, ma'am.
31st of May.
Yes, ma'am.
Yeah, please, Your Lordship. But willful disobedience of order dated 17/2/2017. If may kindly peruse the order dated 17/2/2017. Here, NJ Katoni are here. Kindly approach.
Where is NJ Kakoti?
It's a leg in other court.
Huh?
Leg in other court.
Why is it for order today? Contempt matter.
Contempt matter.
Contempt of which order?
Contempt for Lordship order dated 17/2/2017.
Page number?
Page Lordship relevant page at page 16 Lordship. And Lordship relevant paragraph starts from page 17 Lordship. Page 16 my contempt. And 11 paragraph to Lordship 7. May I read? The instant case petitioners were appointed in the year 1989. They have rendered service for more than 28 years of now. As a matter of fact, they were paid salary up to July 2007. This is for a period of 18
The
years.
amount has not been released till date.
Not released till that.
Why?
Thereafter, Lordship,
Call him, call him.
Oh, yeah.
Please call him now. Wait for a while.
No.
Well, the matter pertains to releasing the monthly honorarium, area honorarium to the female attendant. Lordship was now finance has already sanctioned it. The authorities in the health department has started the disbursement, and almost half of the petitioners have already got. So Lordship will post it after 7th of May. In the month of June, in the meantime, I will place the progress report.
Yeah.
Well, I have to verify Lordship who has received or not.
It is
Many of the
by
petitioners.
Standing Council Health Department.
Health.
The report that pursuant to the sanction receipt,
Well,
the disbursement
started
of what stipend?
No, honorarium.
Honorarium.
Area honorarium.
Area honorarium
To the female attendant.
female attendants have been initiated, and the number of female attendants being up to
Yes.
have also been their area honorarium.
Well,
So, it's up that the matter is after 3 weeks.
4 weeks, fellow. Let me
4 weeks, after which, by which time the status of
Yes.
the payment but can be made. Era. Learned counsel for the petitioner submit that he has complete instruction that the submission made by the Lord's counsel that they that also have submission after 4 weeks.
Slight correction, so far as the amount is concerned, this will cover only the contempt petition, not the other one. So that part may be clarified. Others,
We are dealing with the contempt petition only.
yes, my lord. No, Lordship has stated, some of the petitioners have been paid, including
many of
other.
them, my lord, left out.
We release the contempt
Only contempt. Some of the
matter will be here after the read ask for
Respondent number 2 in item 59, you know.
respondent number
2 in item 59.
in item. You are appearing for petitioner name. Give your fill up sheet. Number.
Oblige, Your Lordship.
No. It be after public to make a mention.
Oblige.
Yes. Yes.
Engage senior counsel out of station, kindly pass up for the.
Why is it for orders? It is submitted that the counsel to the petitioner is out of station. Matter be listed for admissions after 4 weeks.
Oblige.
Please, Lordship.
Yes.
Lordship, earlier occasion, government advocate submitted that Lordship record has already received, Lordship. And Lordship, now matter may be come up for admission, Lordship.
Yes.
Lordship, the record has received, Lordship. It's any date, Lordship.
It is submitted by the council's respondent council
month
to
of
the
May.
records called for availability. Matter is required to be listed for admission. Accordingly, matter is listed for admission on 29th of May. Interim order passed earlier will continue the next dates. Interim order passed in IA 3886 of 2023 will continue to the next date.
Okay. Date 29.
29th of May. And appears for the report to read the property matters.
Lovely.
Yes.
Is coming.
It's coming.
Yes. Lordship, one Lordship, more important thing, Lordship, as per order dated 9/2/2024, Lordship.
Yes, yes. Area salary not received. Why? Not released. 4 months
No,
time.
no, madam, not released. In fact, the reason for not releasing the area salary, madam, I have brought in record by way of the affidavit, madam.
This amounts to contempt. Where is the affidavit?
Affidavit, madam, I have filed it on, my lord, 30th of March, madam.
Yes. What is the ground?
In fact, my lord, kindly come to the instruction I have written.
Paragraph 9 and 10.
Yes, madam.
The second, Lordship, one cabinet meeting was held, and as per the cabinet meeting, Lordship, petitioners could not be accommodated as due. They're saying that petitioners could not be accommodated.
Paragraph 9 and 10, madam.
Paragraph 9 and 10.
Yes. Please read.
That the answering respondents humbly begs to state that the petitioner participated in the said screening process by the submitting their documents. Upon verification, it is found that the 16 numbers of petitioners out of 19 petitioners were approved by the government for accommodation as tutor as per the cabinet decision. However, they retired prior to the cabinet decision and hence they could not accept their fresh appointment letter. From the report of the director, it is seen that the petitioners were not regular in school since 2007. That in view of the aforesaid circumstances, the petitioners, though subjected themselves for screening under illegal, irregular category of teachers, however, they could not accept the fresh appointment order since they retired from service prior to the cabinet decision. Further, report reveals that the petitioners were not attending their duties regularly since 2007. Hence, their claim for salary could not be considered in terms of the direction passed by this honorable court in order dated 17/2/2017 passed in 3286/2014. Hence, the non-compliance as alleged in the instant contemplation is not deliberate and intentional, and the respondents could not comply with the direction due to the change of circumstances, which is not willful and deliberate and beyond the control of the deponent.
What was the direction the court?
Direction, my lord.
Direction is to Lordship. Respondents are directed to release the area salary of the petitioner from August 2017 within a period of 4 months from the date of receipt of a certified copy of this order. Current salary for the month of February 2017 shall be released within a period of 3 months from the date of receipt of the certified copy. This was the direction. And now, dear Lordship, taking a complete
Where is the
different
question
view.
of cabinet decision coming?
Yes, madam. Where is the question of
Well,
cabinet decision?
these petitioners will participate in this because they were identified as illegal or irregular teachers. So their salary were stopped in the year 2007. So they subjected to themselves in screening committee constituted pursuant to the order of this honorable court, my lord. And in that screening committee, they have participated, my lord. And out of 19, 16 petitioners were found to be illegal or irregular.
So then you file a review against this order.
My lord, they have not filed a file review. Lordship. They have not
There is a
filed
direction that you have to pay.
And as per the last
All these events are subsequent events.
Yes, my lord, it is subsequent event.
Right?
It is subsequent. In fact,
not exactly subsequent because my lord, this order was passed in 2007, my lord, 17, my lord, and they have appeared in the screening process in 2014, my lord.
But these are not part of the order.
Yes, these are not part of the order.
Then, which means that the court was not aware that they had already appeared before screening committee and
Yes, that was.
they had already retired prior to appearing before the screening committee. That's
No,
what you're saying.
Yes, my lord. They have retired before the cabinet taking the decision.
So cabinet decision, screening committee is pursuant to cabinet decision.
Yes, my lord. In 2010,
First there was a
cabinet decision to
Then
constitute the screening committee.
screening committee.
Then screening committee was
So, but
constituted.
they retired before the cabinet decision.
No, my lord. They have participated in the screening process. Thereafter,
No, you see your para 9.
yes, my lord.
They retired prior to cabinet decision.
Cabinet decision to accommodate those illegal irregular teachers.
Okay,
There
subsequent cabinet decision.
yes, my lord. Earlier, to constitute a screening committee, there was a cabinet decision. Then, my lord, to accommodate them as teacher, another cabinet decision, my lord.
So out of the total 19,
Yes,
16 had retired.
yes, my lord.
Now what happened to the 3?
All have retired. All the petitioners have retired.
Before the cabinet decision.
No,
Out of 19, my lord, 16, they were offered the fresh appointment order, accommodated as teacher or tutor, as per their eligibility criteria. As regards the other 3 is concerned, my lord, they have not found.
How many retired before the second cabinet decision? Not clear from your parents.
Yes, my lord, I have
It
that.
appears that there are 16 people who were retired.
In fact, my lord, on other day, I have submitted an instruction received from the department. That instruction, a list was there, my lord.
Okay, you prepare it, come back on Friday. Monday.
Monday, my lord, yes. I'll
Matter registered on Monday. By which date the respondent will be apprised before that by the order passed by coordinate made which the contempt by has not yet been complied. Could not be complied. Let the matter be complied. Yes.
Obliged.
Okay.